Yes. Applying to condition, my lord, there is no eyewitness, my lord. PW1 is the informant, my lord.
Just a minute. Two persons face trial.
Yes, my lord.
Kailash Behera and Seema alias Seemanchal Behera.
Yes, my lord.
Charges were under section 302-201-34 and Kailash was also charged under 302-109. And what is the operative part of the judgment? Acha. Please
Page
come
29.
to page number 28.
Yes.
29.
28
ଆସନ୍ତୁ ଆଗେ କଣ ହେଲା ସେଇଠି ଜଣା ପଡିଯିବ ସେ paragraph 16 ରେ
In view of the above analysis of the materials on record, I am of the opinion that the prosecution has successfully proved its case against the accused Seema beyond any shade of doubt, but signally failed to establish its case against the accused Kailash for the alleged offence under section 302-34-109 IPC. In the result, accused Kailash is found not guilty of the alleged offence under section 302-34-109 IPC, acquitted under section 235-1 of the CRPC, but accused Seema is found guilty of the offence under section 302-201 IPC and convicted under section.
Okay, so one was acquitted,
Yes.
another one was convicted. You come to the FIR, let us see.
FIR is the page 38, my lord. मस्ती चोरिया स्वाई पिता हाड़ू स्वाई ग्राम बाहड़ा पद
केते से चोरिया स्वयंला PW1.
चोरिया स्वाई द PW1 my lord.
Read it out.
पिता हाड़ू स्वाई ग्राम बाहड़ा पत्र थाना भंगनगर लिखि जणवा रिपोर्ट एही कि जे गतता 11/2/2003 अपराह्न प्राय 3टा समय मु रिपोर्ट करिथिलि कि मोर पुओ संतोष ओरफ सुकुटा स्वाई केवाडे चली जाइछंती ताकू आमे खोजियारे पाइल नाही गतता 8/2
This Santosh is the deceased.
Yes, my lord.
Okay.
गतता 8/2/2003 रिक्त संध्या सकाळ 8 घंटा हेब आम घरକୁ आसी मोर बड़ पुओ संतोष कुमार स्वाई और सुकुटाକୁ चढ़ियापल्ली ग्रामर सीमा बेहेरा पिता बाउरी बेहेरा और
Seema Behera is the appellant.
Yes.
Yes.
सुकुटा ओरफ पेटा PW9 my lord. बेहेरा पिता गांडू बेहेरा डाकी नेले मोर स्त्री पचारियारू बापांगी जीवु बोली कहिला ता परदिन अर्थात 9/2/2003 रे मोर पुओ न फेरिबारू मोर स्त्री
तार स्त्री माने PW1 स्त्री किए
PW2 my lord.
PW2 अच्छा
न फेरिबारू मोर स्त्री पेटू ओरफ सुकुरु बेहेरा को पचारिबारे से कहिला तो पुओ हाथी घोड़ा जीव बोली कहि पळाइला
पेटू से पहला PW9.
Yes my lord.
Yes.
तो पुओ हाथी घोड़ा जीव बोली कहि पळाइला तापरे आज अर्थात 13/2/2003 तारिख पर्यंत मोर पुओ न फेरिबारू मो ग्रामर समस्त लोकଙ୍କୁ ଏହି ବିଷୟରେ ଜଣାଇଲି ଗ୍ରାମବାସୀ ମିଶି ଚଢିଆପଲ୍ଲି ଗ୍ରାମର ସୀମା ବେହେରା ପିତା ବାଉରୀ ବେହେରା ଏବଂ ପେଟା ଓରଫ ଶୁକ୍ରୁ ବେହେରା ପିତା ଗାଣ୍ଡୁ ବେହେରାକୁ ଆମ ଗାଁରେ ଅଟକାଇ ପଚାରିବାରେ ସେମାନେ କହିଲେ ଯେ ପୁଅ ସନ୍ତୋଷ କୁମାର ସ୍ୱାଇଁ ଓରଫ ଶୁକୁଟାକୁ ସେମାନେ ଡାକି ନେଇ ବାପାଙ୍ଗୀ ଠାରୁ ଅଳ୍ପ ଦୂରରେ ନଦୀ ପାଖ ଜଙ୍ଗଲରେ ସୀମା ବେହେରା ମୋର ପୁଅର ପାଟିକୁ ଧରି ପେଟକୁ ଛୁରୀ ଭୁଷି ଦେଇ ଜୀବନରେ ମାରିଦେଲା ସେଠାରେ ପକାଇ ଦେଇ ଚାଲି ଆସିଛନ୍ତି ତ ଘଟଣା ପେଟା ଓରଫ ଶୁକ୍ରୁ ବେହେରା ଆମ ଗ୍ରାମର ରମେଶ ବିଷୟ ପିତା ବାଉରୀ ବିଷୟ କାଳିଆ ସ୍ୱାଇଁ ପିତା ଉଦୟ ସ୍ୱାଇଁ ପିତବାସ ବାଟିଆ ନାରାୟଣ ଏବଂ ଅନ୍ୟ ଗ୍ରାମବାସୀଙ୍କ ସାମ୍ନାରେ କହିଲା ସୀମା ବେହେରା କହିଲା ଯେ କୈଳାସ ବେହେରା ପିତା ହରି ବେହେରା 1000 ଟଙ୍କା ସୀମା ବେହେରାକୁ ଦେଇ ମୋର ପୁଅ ସନ୍ତୋଷ ସ୍ୱାଇଁ ଓରଫ ଶୁକ୍ଲାକୁ ମାରିବା ପାଇଁ ପଠାଇଥିଲା
କୈଳାସ ବେହେରା has been acquitted.
ପ୍ରକାଶ ଥାଉ କି ମୋର ପୁଅକୁ ସାଥିରେ ଧରି ଯିବାର ଗୁରୁବାଡି ଗ୍ରାମର ଲତା ଦଳ ବେହେରା ପିତା ଲକ୍ଷଣ ବେହେରା ଦେଖିଛନ୍ତି he has not examined ଲତା ବେହେରା has not examined
କଣ ର କିଏ ଗୋଟେ
ଲତା ଦଳ ବେହେରା
he has not been examined.
Yes.
Okay, ସାଥିରେ so and so ଗ୍ରାମ ଦେଖିଛନ୍ତି. No, but Lasin has been seen PW1 ମଧ୍ୟ କହୁଛି ତ ଆମ ଘରକୁ ଆସି ମୋର ବଡ ପୁଅ so and so କୁ ଡାକି ନେଇଗଲା ଏବଂ ମୋ ସ୍ତ୍ରୀ ପଚାର ମାନେ PW2 may be also a witness to the last scene.
Yes, PW1 and 2 has stated my lord.
Yes.
Petavera has called the deceased my lord, not named in the Sima Behra. So Lord, she claims the PW1 my lord statement.
Okay, so this is the
Yes,
now it's a case there is no direct evidence.
Yes, my lord.
All right. Okay, now
Page 52, my lord.
PW1 is 52.
Yes.
Yes.
I am the first informed of this case. I know both the accused persons standing in the dock. They are Sima Behra and Kailash Behra. Accused Kailash belongs to my village and accused Sima belongs to Chodhiapalli. The occurrence of this case took place about 1 year and 2 months back. About 1 year and 2 months back, I was not there in my house, but my wife was there in my house. So also my
Why
son.
means PW2?
Yes, my lord.
Yes.
So also my son Sukuta Singh alias Santoso, on the date of the occurrence when I returned to my house, it was about 7 p.m. And my wife told me that my son Santosh alias Sukuta, being called by one Peta Behera, had accompanied with
Petavera is PW9,
nine,
bro. Okay.
had accompanied with him to Bapangi. My said son did not return to the house by 8 p.m. Therefore, I proceeded to the house and said Petavera, in order to ask me regarding the whereabouts of my son, said that Petavera told me that my son had gone to Hattigoda. I returned to my house and on the following morning, I proceeded to the Hattigoda in search of my son. I had also inquired in the house of my sister at Hattigoda regarding my said son, but my sister told that he had not come to her house. On the next day, I sought my son, but in vain. At about 5 p.m., my villagers, namely Ramesh Bisoi, Padu Sahu, Kailash Swai, Kalia Swai, and others have brought both the accused persons and tied both the accused persons. Ramesh Bisoi had given 3 to 4 slaps to accused Sima Behra and
Ramesh
asked
Bisway is PW
Ramesh Behra is PW
or not exactly?
not exactly. Ramesh Behra
is not
No, not
is
exactly. Not
not
exactly. Okay. 3 to 4 slaps.
3 4 slaps and accused Sima Beher and asked him regarding my son Sukuda Swai. Accused Sima told that he had murdered my son Sukuda Swai along with Peta and Kailash by stabbing on the chest of my
That means
son.
PW9.
Yes, my lord.
Okay.
And by cutting his throat by stabbing on his belly. One 1 mile away from the Bapangi and threw the dead body inside the ditch. The ditch is situated inside the jungle, and this jungle is known as Bapangi jungle. Thereafter, described Vidyadhara Mahanti had described the affair as per my instruction, and I put my signature in it after it was read over and explained to me, Executive 1, in the affair, and Executive 1/2 is my signature, to the signature of the scribe Vidyadhara Mahanti. Cross signature. GSS Shetty by accused Siman. Vidyadhar Mahanti belongs to my Vejiput. Vejiput is the distance 4 miles from my village. Executive 1 was described at the electric powerhouse at Bhanjanagar near petrol tank. Affair was described at about 5 am. I cannot say the date of the describe of the affair. 5 days after the missing of my son, the affair was described. I lodged the affair at about 6 am. I alone proceeded to the Bhanjanagar PS and present the written report. Executive 1. Regarding the occurrence, I was examined by the police during investigation, soon after lodging of the affair. I cannot say the exact date and the date of death of my son, said son. I reported the occurrence at PS on Sunday. I had not been to the place where the dead body of my son was lying. Sima and Peta were tied in the front of my house and on the middle of the road of my village. The accused person were tied at about 5 p.m. More than 100 persons had gathered at the place where both the accused persons were tied. Some of the villagers at Jogimari, Baharapadar and Chodhiapalli were also there at the place where the accused person were tied. Prior to tying of the accused person, I had already lodged a report at Bhanjanagar regarding missing of my son. The first report I submitted orally, and the second report I submitted in writing. I have only presented only one report in writing at the PS. After presenting the written report at the PS, I returned to my house at about 8 or 9 a.m. Tikri Pradhan is my sister, and she is of village Hatiguda. Hatiguda is at a distance of 1.5 mile from my village. I am cultivating the land of Vidyadhara Mahanti, who is the scribe of the affair. On the very day of the exact judicial confession, extrajudicial confession made by accused Sima regarding the causing of death of my said son, police came to my village and took both the accused person to PS. I do not know any Sudarshan Naik. My deceased son was a daily laborer prior to his death. My son was not working under a specific person as a retained laborer. Accused Sima had never made any extrajudicial confession before me that he, along with other accused Kailasa Behra, committed murder of my son Sukuta Swain, alias Sukuta. I had not been to the place where the dead body of my son was lying. It is not a fact that I did not state in my report by the Executive One that I had been to the house of Peta Behra and asked him regarding the missing of my son, and he told me that my son had been to Hattiguda. It is not a fact that I did not state in my affair that my villagers Ramesh Bisoi, Padu Swai, Kailash Swai, Kalia Swai, and others have tied both the accused person in front of my house. It is not a fact that I did not state in my report by Executive One that being slapped by Ramesh Bisoi, accused Sima made extrajudicial confession that he, along with other accused, stabbed my son on his chest and belly and cut his throat and murdered him. It is not a fact that the accused person has never murdered my son Sukuta Swain. It is not a fact that the accused person Sima had never made any extrajudicial confession, and I am deposing falsely. It is not a fact that accused Sima had never made any extrajudicial confession that he, along with Kailash Behra, committed the murder of my son and son Sukuta. It is not a fact that I am deposing falsely. Vidyadhara Mahanti was the vice chairman of the Bhanjanagar NSC. It is not a fact that at the instance of said Vidyadhara Mahanti, I have this false case against the accused person.
So from PW1's evidence which you have placed,
Yes, ma'am.
as we find that this man was not there when the deceased left the house, right? He left the house along with PW9. And to that effect, he got the information from his wife who has been examined as PW2, right? And so far as this extrajudicial confession, apart from that he was tied and assaulted and then it is made, though he has stated in chief examination that this appellant told that he murdered the deceased, but again in the cross-examination paragraph 5 he has stated that accused Sima means this present appellant, had never made any extrajudicial confession before me that he along with so and so committed the murder of the. So this part is there. So neither he has is a witness to the last scene, nor
No,
huh?
no, he is not.
And this extrajudicial confession is also because he himself is not aware that. So let us come to PW2 because he seems to be a witness who has seen the uh, uh, deceased leaving the house and with whom he might have stated.
She has also stated the deceased has gone with the PETA.
No, that is PW1 has also
Yes,
stated. So let us
PW2 has stated
place
same.
it. Let
The
us.
infant Churia Swain is my husband. This is Santosa alias Sukuta was my son. I know the accused persons, namely Sima Behra and Kailash Behra. My said son died about 1 year and 2 to 3 months back. I have got 5 daughters and only one son, and he was the said deceased. One Petta Behra alias Sukura Behra arrived PW 9 mile. Petta Behra alias Sukuru arrived in my house and called my son Sukuta. And my son told me that he was proceeding to Bapang along with the said Petta. On the said day, my said son Sukuta, who had accompanied with Petta, did not return back till night. My husband returned to the house on that date by 8 p.m. I told my husband that my son Sukuta had been to the Bapangi along with Peta, but had not yet returned. Said Peta belonged to village Chodiapoli, which is nearer to my village, and my husband on the said night went to the house of Peta, asked him regarding whereabout my son Sukuta, and my he told to my husband that Sukuta had gone to Hattiguda. On the following morning, I along with went to the house of Peta and asked me regarding my son Sukuta, and he also again told that Sukuta had gone to Hattiguda. My husband reported the matter at PS regarding the missing of my son Sukuta. On the fifth day of missing of my son, my villagers have brought Peta and Sima, and the villagers tied both the Peta and Sima in front of my house and assaulted them. And at first, accused Sima told that he, along with Peta have killed my son, and at that time I was present. Subsequently, Peta also stated that he, along with Sima, had killed Sukuta. Lord's kindness. Both of them have told that they took Sukuta to Bapangi and they killed Sukuta by the side of a river, small river, and threw the dead body there. My husband reported this matter at Bhandanar PS.
Now, this witness has excluded the other accused who has been acquitted. Kailas, because the number one has stated that 3 persons were in fact brought, I think, regarding my son, so accused Sima told you again, brought both the accused persons. Both the accused persons say and tired so and so.
P9 and present accused person. Crossing. I had disclosed to Ramesh Bisoi, Kalia Swai, and others of my village regarding the missing of my son Sukuta. Peta came to my house on the Saturday in Odia month of Magho, and on that day my son accompanied Peta in order to proceed to Bapangi. On Sunday, my husband reported in the PS regarding the missing of my son Sukuta. On Thursday, my villagers had brought Sima and Peta, and on the said day, both of them were assaulted by the villagers. Sima and Peta were tied on the middle of the road against a pole. Both of them were tied in a big rope against a pole in the middle of the road. I cannot say who tied them. I cannot say which villagers have assaulted, said Peta and Sima. I was at a distance of about 4 to 5 feet, 7 to 8 feet, when Sima and Peta stated that they have killed my son Sukuta. About 1,000 people have gathered at the place where Sima and Peta were tied. I was near both the accused persons when they confessed their guilty. Being asked by Ramesh Bisoi and Kalia Swai also what happened to my son Sukuta, then Peta and Sima have told that they have killed my son. On the said Thursday, police arrived in my village at about 9 p.m. and took Sima and Peta. Sima and Peta were tied at about 5 p.m. Of the said Thursday. My husband reported regarding missing of my son at PS on a Thursday and returned to the house, and when he arrived in the house, by that time Sima and Peta were already tied. I did not go to the spot where the dead body of my son Sukuda was lying. I was examined by the police during investigation, for the defense had drawn the attention of the witnesses to her previous statement. It is not a fact that I did not state to the IO that my son Sukuda did not tell me on Saturday that he has to proceed to Bapangi along with Peta. It is not a fact that I did not state to the IO that when my husband uh, returned to my house on the said Saturday at 8 p.m., I told him that Sukuta, being accompanied with Peta, had gone to Bapangi and had not yet returned. It is not a fact that I did not state before the IO that my husband went to the house of Peta on the night of the Saturday and asked Peta about my son Sukuta, and Peta told my husband that my son Sukuta had gone to Hatigura. It is not a fact that I did not state before the IO that on the morning on Sunday I personally visited to the house of Peta and asked him regarding my son Sukuta, and he told me that my son had gone to Hatigura. It is not a fact that I did not state before the IO that my villagers have tied Peta and Sima on the middle of the road of the village and assaulted them. It is not a fact that it is not a fact. It is also not a fact that I did not state
These
before the IO that
contradictions have been proved through the investigating officer.
Your से कहीं से
PW9 कितने नंबर से साक्षी के
investigating officer तो PW12 में
PW12
yes my lord
पेज कितने नंबर ये जो contradiction part टा पूछ रही थी पेज कितने आप पैराग्राफ
77
पेज 77
हाँ yes ma'am
पैराग्राफ कितने
paragraph 3 ma'am
3
yes
77
at paragraph at page 79
70 79 cross examination
cross examination
PW2 रो जो
हाँ,
आपण if
तार
टा
सीटा
पचारले
prosecution part परे
cross examination I have not examined Vidyadhara Mahanti
ओहो
जोटा
अच्छा।
confront करथले मैं
जोटा confront करथले सेटा तो
PW2 had not stated
प्रमाण
para
करे
para
हाँ।
last part para
I have
so
अच्छा
para
ये
for
right last
part,
line
हाँ,
ये तो आरंभ अच्छा ये come to page number 80 80 रो last but one line से तो आरंभ करो पाइले 80 पेज रो
yes ma'am yes
PW2 had not stated before me से तो आरंभ करो
PW2 had not stated before me that her son Sukuta had stated the day, that is Saturday, specially before her regarding his departure with accused Sima and Sukuta. PW2 had not stated before me that she has not told before me that she informed her husband that Sukuta had not returned yet, who had gone with Sukuta and Sima to Bapangi forest. PW2 had not stated before me that specific day, that is Saturday, when his son had gone to the house of Sima and Sukuta. PW2 had not stated before me that the villagers, after tying with a pole in the village danda, assaulted them, and that during the assault, accused Sima disclosed before the villagers that to have killed Santosh with the help of Peta. PW2 had not stated before me that accused Peta had also disclosed during course of the assault that he, along with Sima, had assaulted Sukuta. PW2 had not stated before me that accused Sima and accused Peta had killed his son and threw the dead body by the side of a river. PW9 had not stated before me
that is not there. Extrajudicial confession part it has been confronted and proved that it was not there in the 161 statement. Okay, so if this last scene, Mr. Mishra, last scene evidence रो जो साक्षी ये होची PW2 कारण PW1 PW2 ରୁ ଶୁଣିଲା
yes
PW2 कहूची last scene actually थिला PW9 ର company रे not so that is the evidence of these two witnesses so far last scene and again extrajudicial confession ର ଯାହା भी evidence ଆପଣ ଆଣିଛନ୍ତି ସିଏ କହୁଛନ୍ତି ଦିଟା accused କୁ ବନ୍ଧା ହେଇଥିଲା କି PW1 whereas ଇଏ କହିଲାଣି गोटे accused अर्थात appellant और PW9 को बांधिथिले तापरे evidence आसिला बांधिथिले तांकू माड़ मध्य मारथिले तापरे जो extrajudicial confession ହେଇଥିଲା ବୋଲି कहउछन्ती but whatever he has stated that has also been confronted and proved that in fact this witness is not a witness to the extrajudicial confession. She has not stated anything. So a part re a जो last scene ଆଉ extrajudicial confession we are now confining to that ଆଉ किए साक्षी अछंती आपण कहले जो FIR रे देखिचंदी बोली से साक्षी एग्जामिन हेलानी परा ଗୋଟେ କହିଲେନି କୋଉ ସାକ୍ଷୀ ଦେଖିଛନ୍ତି ବୋଲି ଲେଖା ହେଇଛି।
Last
PW9 is also a witness to extrajudicial confession.
PW9 is
No,
on the pilot.
ନାଇଁ ଏଇଠି ଗୋଟେ ଲାଷ୍ଟ ଲାଇନ ରେ ଅଛି FIR ରେ ପ୍ରକାଶ ଥାଉ କି ମୋ ପୁଅକୁ ସାଥିରେ ଧରି ଯିବାର ଗୁରୁବାଡି ଗ୍ରାମର ଲତା ଦଳ ବେହେରା ପିତା ଲକ୍ଷ୍ମଣ ଦଳ ବେହେରା ଦେଖିଛନ୍ତି।
He
ଏଇଟା
has not
FIR ରେ
examined.
ଲେଖା ହେଇଛି। He has
But
he has not been examined. Now the evidence of PW9 you say.
Yes.
All right, you place that PW9.
PW9 is the PETA malord.
हाँ जो
was assaulted.
बुझिले बुझ
Yes.
he is the person with whom PW2 say that there was last seen.
Yes,
Okay,
ma'am.
just
Page 79. I know the
and he was also the person according to PW2 was brought by the villagers, tied and assaulted,
Yes,
and he also confessed.
Yes, ma'am.
Yes.
Okay, now
I know the informant Choria Swami. I know both the accused person named Kailas Behra and Sima Behra standing in the dock. The witness identified both the accused person. This is Supraji, also known as Santosh Swami. About 2 years and 3 months back, I myself said this is Sukuta and accused Sima Behra proceeded to the Bapangi jungle by 2 cycles. I was in Pilon rider in the cycle of Sima Behra. We started from our village at about 7 a.m. and reached in the shade jungle at 9 a.m. There is a deity inside the shade jungle in the name of Ma Bapangi. I, along with the shade 2 persons, broke coconut before the shade deity. Thereafter, Akir Shima told me to guard the cycle, and he, along with the deceased Sukuda, went inside the forest. Half an hour thereafter, Shima returned to me alone and said Sukuda was not with him. When I asked Akir Shima regarding Sukuta, he confessed before me that he killed Sukuta by means of a knife. And when I asked Akir Shima as to why he killed said Sukuta, Akir Shima threatened me to kill. When I expressed my mind that I would disclose the occurrence to the parents of the said Sukuta, Akir Shima rushed towards me to assault. Thereafter, both of us left the jungle and proceeded to our village. While cycle of Sukuta was laying near the hill, myself and Akir Shima proceeded to the village on the cycle of Shima. I did not disclose the occurrence to my villagers as Shima had threatened me to kill me. But subsequently, the villagers had caught hold of accused Shima and assaulted him and asked me regarding the whereabouts Sukuta. And Shima told that Sukuta fell down in the ghai and he died. But I disclosed before the villagers that it is the accused Shima who killed the said Sukuta.
So he has omitted all those parts that he himself was tied, assaulted.
This is escort part B.
So this is, and initially perhaps he was the accused in that case. He subsequently, as it appears,
FIR, I don't think he has been.
He has not been taken as an accused. Even 319 has not been taken.
Yes, no, he was not in the charge sheet, Lordship.
charge sheet भी नଥିଲା.
No.
319
In the FIR also, he has not been named, Your Lordship.
No, that is right. But the statement indicates both the statements. ମାନେ PW1 ର statement ଆଉ PW2 ର statement କୁ ଦେଖିଲେ PW1 ର again I went to asked him ତାପରେ my husband took the pictures of PW2 was PW1 ଟା ଲେଖା. On the next day I searched for the son but in vain at the son villagers named this one so brought both the accused persons and tied both the accused persons. Ramesh gave Swanso to Sima. Sima is the appellant again. Asked him regarding my son. Sima told that he had murdered my son along with Peta and Kailas by stabbing on the chest of this Swanso. This is again, but in the cross-examination stated that he has not made any extrajudicial. That is paragraph 5. And PW2 on the other hand stated that the villagers brought PW9 and Sima.
Yes.
So that means he has left the other accused. Kailas which left Kailas, okay. And both of them were tied in front of Swanso. And Sima told that he, along with Peta, have killed my son. So that also goes contrary to the statement made by PW1 because the disclosure was that both of them along with Kailash murdered. But here Peta said, Sima said that Sima told that he along with Peta means PW9 have killed my son and he was present. Subsequently, Peta also stated that he along with Sima. So this name of this Kailash has been given uh, completely go by this in the extrajudicial court. Apart from the fact that he has not stated anything in that 161 statement which has been proved. Okay, so what is there in the cross examination? Let us come to PW
9.
9, page 71.
Ah.
I have not seen the accused Sima kill Sukuta by means of a knife. When Sukuta and Sima have left the said deity premises, I was sitting on the veranda shop of said deity premises. I do not know who called Sukuta from his house to proceed to Bapangi jungle. I was called by accused Sima from my house to go to Bapangi jungle. Sukuta also called me along with Sima. I was also brought to PS by police on suspicion and I was also detained in the PS for 5 days and was interrogated by the police. In the PS, I was also assaulted by the police and police instructed me to speak the truth. Only a slap was given to me at police station and I was directed to speak the truth. 5 days after the occurrence, I was taken to police station. First of all, I disclosed the occurrence to my villagers. On the day, police took me to the police station and I also to the police. On the day, the police took me to PS. I was never assaulted by the villagers. My villagers have tied Sima Behra against a pole and assaulted him. Villagers have tied Sima and assaulted him at about 7 or 8 p.m. of the night, but at the time police were not present. Police arrived in the village at about 10 p.m. Police took me alone to the PS. I was not examined by the police in my village, but police examined me in the PS. On the date of occurrence, I, along with Sima, returned to the said jungle and reached in the village at about 11 a.m. But on that date, the parents of Sukuta did not ask me anything regarding Sukuta. Nobody of the village also asked me regarding Sukuta. Bapangi jungle is situated at a distance of 10 to 15 kilometers from my village. We reached the jungle at about 9 a.m. and returned from that jungle at about 9:30 a.m. It is not a fact that I did not before that I along with Sima and Sukuta reached at the Bapangi jungle at 9 a.m.
Contradiction. I did not state before. State
Yes.
omit inadvertently.
But I stated.
But I stated before the IO that we reached the Bapangi jungle at 11 a.m. Chodhyapalli and Bahada Padara is one village. Chodhyapalli is at a distance of half kilometer from Bahada Padara. Akiju Sima belongs to village Chodhyapalli. I stated before the police that my village is Chodhyapalli. I stated before the IO that my village is Bahada Padara. It is not a fact that I have not specifically stated before the IO that Sima returned alone half an hour after alone. After 50 villagers have assaulted the
Assembled
the place where Sima wasted, I did not disclose the occurrence to my parents on the date of occurrence. It is not a fact that on the date of occurrence, accused Sima had never come to my house and called me to accompany with him to Bapangi jungle. It is not a fact that I am deposing falsely that I proceeded to Bapang jungle as a pillion rider of the cycle of Sima, and Sima was riding the cycle. It is not a fact that I had never been to Bapang jungle on the date of occurrence, along with Sukuta and Sima. It is not a fact that neither Sima told me to guard the cycle near the said deity, nor Sima and Sukuta proceeded toward inside the jungle. It is not a fact that I am deposing falsely that when Sima came alone and I asked him regarding Sukuta, he told me that he killed Sukuta by a knife. It is not a fact that I am deposing falsely that Sima had threatened me to kill the case. I disclosed the occurrence to anybody. It is not a fact that I am deposing falsely that Sima told me that he killed Sukuda by means of a knife. It is not a fact that I am not pulling on oil with accused Sima. Therefore, I am deposing falsely against accused Sima. It is not a fact that being threatened by police, I am falsely implicated Sima with that of the occurrence in the question.
So, who has conducted postmortem? PW3.
Yes.
Stab injuries are there.
Yes.
Cause of death is on account of stab injuries. So it appears from this man's evidence that he was at one point of time was also in the list of suspects. He was taken, detained for 5 days, assaulted. That is his evidence.
Yes.
And then he has been made a witness to the occurrence. And if evidence of PW2 is taken into account at all, of course, he has not stated that this person was also tied in that village where 50 persons had assembled. And
Virtually an approver.
mm,
Virtually an approver, but has not been shown as an accused.
and very cunningly he has exculpatory statement. 30 section 30 re, of course, he was not co-accused. It will be that is to be taken as a last resort, the confessional statement of co-accused. But if it is an exculpatory in nature, then it cannot be relied upon. The accused must himself implicate as well as the others.
That is
But,
has not been shown as an accused.
But
been
he's
shown
not
as
an
an
no,
accused.
that's you are right. But even if he would have been suppose
Accused.
somebody he himself leaks that as if he was just observing everything and the other accused was doing, that means he is exculpating himself.
Not sure.
Right. So that would they say that such type of statement would not be. However, if these are the only evidence or anything
And
else.
section 27 leading to discovery of the body, Your Lordship.
সেটা
which,
কার
uh,
instance?
The IO has
Oh,
stated.
IO.
But the accused still has given no explanation to that. Those 3 points,
Accused কোন explanation দেব মানে
Lord's,
IO যদি leading to discovery গলা সেটা if it is at the instance of the accused, he would have led to the police to the a counseling place
yes,
of
yes,
concealment.
that is
That
what
is
has happened.
27.
27 is
Section
that? No, no,
27,
you
Your
said that we thought that
No,
it
no,
is
27 has been recorded.
Yes, Your Lordship.
who is that witness?
The
PW?
IO, Your Lordship.
IO is PW?
12.
Okay, let us come to that.
Page 77.
I recorded statement of the accused Sima.
পড়িলে IO evidence of place করো
77 well.
হ্যাঁ place
That on 13/2/2010, I was SI of attached to the Bhandanar PS. On that day at about 11 p.m., I received a written report from the informant Surya Swami, which reveals a cognizance case, and I registered this case in absence of IIC. Executive 1 is the plain affair, plain paper affair received by me. Executive 1/3 is my endorsement with signature. I examined informant recorded his statement under section 161 CRPC. On 14/2003, I examined the witnesses and apprehended the accused persons. Accused Sima Behra admitted to have committed the offense and gave a recovery of a weapons of offense and dead body of the deceased. I recorded the statement of accused Sima Behra under section 27 Evidence Act. This is the said of the statement under section 27 Evidence Act, Executive 4/1 and 4/2 is my signature. So admitting accused Sima Behra led the police party and witness and showed the dead body showed the dead body lying in the nala in the forest, and the weapon offense was on the belly of the deceased. At that time, I prepared the spot map marked at Exhibit 8. Exhibit 1 by 8 by 1 is my signature. I conducted the inquest on the dead body and prepared an inquest report in the presence of witnesses. This is the inquest report already marked as Exhibit 5. Exhibit 5 3 is my signature. I sent the dead body for post-mortem examination as per a dead body challenge and a command certificate through the escort constable. This is the dead body challenge prepared by me, marked as Exhibit 9. Exhibit 9 by 1 is my signature. This is the command certificate issued in favor of escort constable, marked as Exhibit 10. Exhibit 10 by 1 is my signature. I seized one old bicycle as per seizure list prepared by me at the spot, marked by 6 by 1. 6 by 2 is my signature. I also seized the sample earth and blood stain earth under the seizure list prepared by me, marked as Exhibit 7 by 1. Exhibit 7 by 2 is my signature. I examined the witness and recorded their statement under Section 161 CRPC on 14/2/2003. I seized the wearing apparels of the deceased. Deceased after post-mortem, after production of the escort constable and prepared seizure list already marked as Exhibit 3. Exhibit 3 by 2 is my signature. On 15/2/2003 at about 9 am, I forwarded the accused in custody with a prayer to the STM for recording their statement of the witnesses Sukuru, Peta Behera under Section 164 CRPC. I received post-mortem report. I left the seized cycle in Jima as per Jimanama. This is Jimanama marked as Exhibit 11. Exhibit 11 by 1 is my signature. Exhibit 11 by 2 is the signature of the Jimadar. I sent the seized exhibit through the STM to RFSL for the chemical examination. This is the office copy of the dispatch letter marked as Exhibit 12. Exhibit 12 by 1 is my signature. The chemical examination report received in the court with reference to the dispatch letter. This is the chemical examination report marked as Exhibit 13. MO1 is the knife already marked, and MO2 is the gonji, and MO3 is the seized full pant. MO4 is the seized shirt. I have examined PW4 Pitoaso Bisoi and recorded his statement under Section 161 CRPC. PW4 had stated before me that father of Santoso told him that other villagers and Santoso left the house and accompanied with Sima Behera and one Peta Behera, and that Santoso had not yet returned, and that when he asked Peta, Sima, they gave meaningless answer, and that when PW4 along with the villagers asked Sima and Peta about Santoso, accused Peta told that Sima Behera had killed Santoso at Bapangi jungle, and PW4 and the villagers asked Sima, he told that he killed Santoso in the forest, and for that accused Kailas Behera had given 1000. PW10 had stated before me that witnesses Sukuru Behera had disclosed before them accused Sima Behera had killed Santosh by means of a knife in the forest, and that he being informed, and they asked accused Sima about the disease, and the accused had confessed before them that he had killed Santosh by means of a knife at Bapangi jungle and thrown the dead body in a ditch, the forest, and that the accused had also confessed before them that accused Kailasa Behera had given 1000 to commit murder of accused Santosh. I have examined PW11 Kumar Swain during investigation. PW11 had stated before me that 13/2003 when deceased Sukuda did not return
You
to
leave
the
it to
house.
come to the cross examination. That is the contradiction part.
I have not examined Vidyadhar Mahanti, the scribe of the FIR, nor cited him as a charge witness. I have examined Lata Behera, daughter of Lakshman Dal Behera, and cited her as a witness, but he has not examined. In the charge sheet, no report was received or lodged in the PS prior to the affair on the allegation that the deceased was missing. I cannot say the name of the accompanying person with the informant at the time of lodging the report at the PS. I have examined Surya Swine, the informant on 13/2003 at about at PS. On 14/2003 at about 10:15 a.m. I proceeded to the spot while I arrested the accused persons when they were in the village.
Yes, continue.
On 14/2003 at about 10 a.m. I arrested the accused persons. On being identified by the informant, many villagers were present at the time of arrest of the accused persons by me. Lingaraja Bisoi, Kumar Swai, Padmanabha Swai, they are being hostile with Padmanabha Swai. As many as persons beside the police staff were present at the time of proceeding to the spot. I have not cited Lingaraja Bisoi as charge witness, though I have examined him during the investigation. It is a fact that I see the wearing apparels of along with the MO one knife by production of a escort constable. After post-mortem examination of deceased, the witnesses I have cited Padmanabha Swai and Kumar Swai, they are hostile male, who were present with the police party the time when the accused person showed the dead body of the
Oh,
deceased.
that they are the witnesses to 27,
27. Yes.
but they have not stated anything
Yes,
yet.
my lord.
No, they got hostile.
Okay, okay.
I have mentioned the boundary of the spot in the spot map. The distance between Bapangi jungle and the spot is half kilometer. Village Baipali is at a distance of 3 kilometers from the spot.
Nice.
I record the statement leading to the discovery under Section 27 Dividends Act of the accused Sima on 14/2003 at the police station. It is a fact that at the time of recording the constitutional statement of accused Sima under Section 27 Evidence Act, Gramaraki, Home Guard and villagers were present. The name of the villagers present at the time of our Pundia Swai, Padmanabha Swai, they are hostile murder, and the others. It is a fact that I had not obtained signature of the villagers in the statement of accused recorded by me, except signature of Gramaraki and Home Guard. After the arrest of the accused persons, they were brought to the police station, and while they were in custody, accused Sima confesses, for which I recorded the statement under Section 27 of the Evidence Act at the PS in the presence of witnesses. I have not mentioned the time of recording the statement and the witnesses Kalia Swai, Kumar Swai and Padmanabha Swai. I have not mentioned the distance of the spot from the PS. The distance of a PS from the spot is 25 kilometers. After receipt of the FIR, I proceeded to the village to arrest the accused persons in the police jeep. I reached the village of the accused persons at 2 p.m. On 14/2003, though I have examined Kalia Swai, Ramesh Bisoi, Pitavasa, Bortia, Usha Swai, and the others in the village, but I have not mentioned time of their examination in my CD.
System justice. There are the witnesses to the inquest are one is Kumar SHRI is PW 11, no?
11
And the
First
other
time.
is
8.
He told it is big hotel malpractice.
no PW
8
no,
is
no, no.
Padmanabh.
Padmanabh.
I think 11 has not been declared hostile.
Kalia school.
Declared hostile.
Hostile.
But
But what is the evidence?
what he has stated that
Ah.
is most important. You see PW 11
The part of evidence that has already come.
on that day, on being called by the police, I accompanied them to Bapangi forest where I
Yes.
found the dead body of
Yes.
so and so.
Yes.
So he has omitted that part that it was not
At
at the instance of 27 रे सेटा ये हला बोली डेड बॉडी पुलिस नेकिनी बाहर करची सेटा ठीक अछि बट accused
He
नेला
exported that.
हाँ जोटा की सेटा नहीं आते
Inquest टाको से हाँ.
That PW7 has stated that, however.
Good.
It was 7.
PW7, my lords. Page 66.
I was looking at my-
He is a home guard man.
Yes, home guard.
Whoever.
Both of them are found, the accused persons so and so, both of them are arrested by the said police. Both of them, while in police custody, disclosed to have sworn. Both of them killed through the dead body so and so. Thereafter, the IO proceeded so and so along with the accused person. But this is contrary to the IO's evidence. IO says that only one accused, that is this appellant. Please just verify it vis-a-vis the evidence of the IO. I think IO said that 27 statement was only made.
Yes,
By
only
Sima.
Sima
Sima,
Bell.
Sima.
And
Only.
he led the. Let us come to again to that PW11. PW11 or 12? 12 is like
12, they are.
12, right? 12. 12 कहला, accused Sima admitted and gave recovery to Swan. So I recorded the statement of Sima. This is the statement. Then accused Sima led the police party to the witness and the witnesses to answer. So,
But here he is not the person who has seen. I had not seen the dead body of the deceased Santosh Swai inside Vapangi jungle as I did not go to the place.
he has this witness.
Yes,
Though
he is not
stated
witness.
initially that both the accused persons
So he
had
is
gone
not
there.
witness to that.
And in fact, the witnesses who had gone there and were present, those who are witness to the inquest, they have signed also. They have stated that they have not whispered anything about the appellant leading the.
Yes.
Because we just read it that evidence of.
That must they have. Inquest part they have accepted.
Inquest part they have accepted.
And
right.
found the dead body is all right.
27 part they are at the instance of
good.
the supplement that is. So now remains the only statement of the IO about the leading to 27 no जो evidence टा आछी IO छड़ा और क्या evidence रहेला
Only IO remains.
only IO
It's not corroborated by rest of the two witnesses.
जो witness मानको नहीं कि नहीं जाई थला एवं सेमाने inquest बेले present थिले sign करथिले सेमाने कहउचंती पुलिस हमकु नहीं कि नहीं गला सेमान totally silent रहउचंती जे
Of course, they have been shown as hostile.
ने hostile टा से part को
करा ही कि नहीं
ना से part रही से part टा let us come to PW 11.
हाँ
PW
confront कराई
confront is hostile, but that is related to just let us see again. PW 11 which is 75. Please come to that. Please read that portion. Chief ru pad jaante. Page 75.
70.
हाँ.
I was not again by the police.
अरे नहीं मो chief ru पढ़ंतु अपन.
I know Choriya Swami.
I know Choriya Swami.
Choriya is that informant PW1. Okay.
I know Choriya Swami and the accused person standing in the dock. I also know the deceased Santosh Sukuta who lost his life 2 to 3 years back at Bapangi Forest. On one day of being called by the police, I accompanied them to Bapangi Forest, where I found the dead body of deceased Sukuta alias Santosh. I found at the relevant time Sukuta was lying dead with a puncture wound on the belly, on his belly in the ditch area. At that time, 4 to 5% of my village had also accompanied with us to the place
of detection.
Of the detection of the dead body of the deceased Sukuta. Police prepared the inquest report in presence of the witnesses, and I
put my signature.
Is my signature. Executive 5 is the inquest report, and Executive 5 by 2 is my signature. Photo of the dead body was taken by the photographer at the instance of police. I came to the Bhanjanar hospital with the person bringing dead body of the deceased. I put my signature on some of the papers, but I do not remember in which paper I gave my signature. I do not know if the police seized the sample earth and blood stained earth along with the cycle from the spot, but the signature appearing on the seizure belongs to me. Exhibit 6 and 7 are the signature. I was not examined by the police. It is not a fact that I had stated to the police that till 2013, when deceased Sukuda did not return to his house, my parental uncle, father of the deceased, told this matter to the villagers of Bahada Padara. And when the villagers, namely Ramesh Bisoi, Kalia Swami, Pitavas Badatia, asked Peta Sukuda, who disclosed before us that he had
that is in the village.
He had seen actually Sima stabbing the deceased with a knife to death and threw the dead body of the deceased to Bapangi Forest. And the accused Sima had threatened him not to disclose this matter to anybody else. And that at the time, and I was present, and that when the villagers asked Sima, he made extrajudicial confession before the villagers by admitting that he had killed Santosh by stabbing with a knife and threw the dead body in the ditch area of Bapangi Forest. And the accused Sima had further stated before us that the co-accused Koilasa had given ₹1,000 to kill Sukuta, and accused Koilasa had stated him that Santosh had illicit relationship with his wife, for which he directed accused Sima to kill Santosh. It is not a fact that I had stated to the police that accused Sima, after making such confessions, led us and the police party to the place where he had killed Santosh, and led us to the place where the dead body of Santosh was lying, and showed the dead body to us, and the police held inquest on the dead body while the knife fire in the belly of the deceased and seized cycle of the deceased. Sample earth along with the blood stain earth from the spot where seizure leaked, and that the police read over the explained the contents of the inquest report and the dead body challan, after which I put my signature. It is not a fact that I am concealing the truth in order to save the accused person from this case.
So that means 27 part, though he has stated earlier, now in the court he has not stated about the only stated that the police took me or us to that place where the dead body was found and inquest was held. He proved the inquest report and his signature on the inquest report. The other witness to this is PW 4. Acha.
Yes, ma'am.
ନାଇଁ ମୁଁ PW 8 ନା 8 ନା ସେ କହୁଛନ୍ତି ଆଇଓ କହୁଛି 2 ଜଣ ଥିଲେ 8 है ଆଉ 11 8 ଟା
Padmanabh
କଣ?
Swami, here also defines
हाँ,
page
Padmanabh.
88.
right, PW8
Padmanabh Swami.
I know
ସେ କହୁନି police instance ଦେଖେଇଲା ବୋଲି
No, no,
ପଢିଲେ
sir,
ପଢିଲେ
I know the informed Surya Swami, who is my co-villagers.
Same
I
as
know
it.
deceased
Same.
Santosh Ali
Same as it.
Sukuta Swami, who was son of said informant. I know both the accused from named Santosh alias Sima, and both of them belong to village Chodhiapalli. During the investigation of this case, police conducted an inquest over the dead body of the Santosh alias Sukuta Swami in my presence and in presence of others. And I have signed in the said inquest report as a witness. I found a knife tied in the
Yes,
bed,
into the belly of.
in the belly of the deceased, and the said knife was affixed to the said belly of the deceased. Exhibit 5 is the inquest report prepared by the IO in my presence, and Exhibit 5/1 is my signature. I cannot say the year and date of the said inquest. The inquest report was prepared at 10 or 11 a.m.
he has not even declared hostile.
PW7 is the other witness.
Who is that? PW7 तो
But
जो
he
type
did not. He did not go to the.
you placed. He
spot.
did not go. Number one, number two, जो दी जन both the नेले बेली कहूनी की. Just again see that. That is contrary to the IO's evidence. IO evidence है only one appellant. That means this appellant Sima. But if you come to the evidence of PW7 कहला both of them where they are in the police custody, and then both of them disclosed that they have done this. Then IO proceeded to so with the accused persons. Of course, he had not gone. So this runs contrary to IO's evidence. So last scene टा जदि पळेला आपनकर मेन जोटा पेज थिला
PW9 your lordship.
PW9.
नहीं
हाँ, पेट्टा.
पेटा आपनकर नहीं आगे आसंतु जी देखी जी जो इन PW9 तो गोटे सस्पेक्ट भीतर आसिला 2 टा थिला प्रथम रु आपनकर विटनेस टू दी एफआईआर भी सेया थिला जे स्त्री ताकू लास्ट सीन सी लास्ट सीन वाला को जे लास्ट सीन होची विथ PW9 राइट
Yes.
तेणु PW9 रो एविडेंस तो हला जे हमें 3 जण जाईथि माने डिसीज भी जाईथला मु जाईथली अपलांट जाईथला and then whatever he has stated that 5 days he was also initially a suspect, all these things. So last scene को बाकी गले भारी आउ रहिला कोन माने आपनकर leading to discovery रो type
Evidence of
And also extrajudicial confession before PW9, which in my humble opinion is very voluntary and deliberate, your lordship. And it has been made spontaneously. And the question that was PW9, your lordship, because they three went together, and after that, the version of PW9 is that the accused and the deceased went further inside the forest, and after a while, the accused returned.
This man himself confessed to have committed the crime. That is the evidence of your witness.
But I would not place any reliance on that.
आपण जोडाक आपणको against रे जीवो ताको आपण omit कर देबे. If you want to rely on the evidence of a particular witness, let us read the evidence in whole. से कोन कहला जे आरो accused को तो टोटल पिक्चर ही नाही आनी थले एई दी जण माने PW9 को आनिले आउ अपेलेंट को आनिले तांकू बांधी किनी गाँ को आइले तांकू माड़ मध्य हला माड़ हला परे दी जण जाको कहिचंत. That is the evidence of PW.
That was under threat and coercion, your lordship. It was not done voluntarily because they were assaulted. That is the version.
No, whatever it may be, that was the initial stage. Then सेही circumstance रे तांकू नेकिनी थाना रे 5 दिन मध्य रखा आइछि. Yes. So how do you say that this witness was initially suspect and he himself also made confession before the others? से admissible हबो कि न हबो, that's a different part. तापर सीए निज पार्ट टाकू omit करछु, which has been pointed out by my esteemed brother, that exculpatory one. तापर तो सी निज माने सेफ साइड को रखी दला. आपण जो एविडेंस रे आनिले एविडेंस रे निज को पूरा सेफ साइड रख दला. Whereas the extrajudicial confession that in the before the villagers I come to that evidence where it has been stated that ଦି ଜଣ ଯାକ ଯୋଉ ବନ୍ଧା ହେଲେ
PW2.
PW2 uh, he
On the fifth, Lordship, page 57.
57, right.
Fifth line, Your Lordship. On the fifth day of missing of my son, my villagers have bought Peta and Sima. And the villagers tied both Peta and Sima in front of my house and assaulted them. And at first, accused Sima told that he, along with Peta, have killed my son, and at that time I was present. Subsequently, Peta also stated that he, along with Sima, have killed Sukuta. Both of them have told that they took Sukuta to Bapangi and they killed Sukuta by the side of a river.
Initially ଆପଣ ଦେଖନ୍ତୁ initially ତାର ଥିଲା ମୁଁ ନିଜେ ବି murder କରିଛି ମୁଁ ଆଉ ଆମେ appellant ଦି ଜଣ murder କରିଛୁ ବୋଲି that is the statement of PW which is of course he has not stated but and then his evidence, his own evidence that I was detained, I was assaulted, one blow, and then I was asked to tell the truth, whatever. Then you are saying that that confession which has been made before PW9.
In any case, this is the center stage of the case.
Yes, Your
PW9.
Yes.
And whether the evidence of IO is to be accepted when other two witnesses have been retracted. Whether it is an evidence under 27 of the Act and whether it is to be taken. Not always that he should be disbelieved, but whether the circumstance shows that yes, it is evidence under 27 vis-a-vis the statement of PW9. Though he is giving a detailed, minute detail of the manner in which these things has happened, his presence cannot be disbelieved along with the co-accused, along with the accused, because he might not be one of the assailant, but his version can also.
This PW9 or initial stage re, we started from our village at 7 a.m. Acha, you see that I myself, the said accused and so proceeded to village. Eita tar evidence ta start heichi ei light re. What he is omitting first, you see that he is omitting that he is the person who called the deceased from his house.
Yes.
That is the evidence of PW2. ହେଲା କୋଉ ଟାଇପର ସେ ନିଜକୁ ସେଫ୍ ରଖୁଛି ସେ ପାର୍ଟ ସେ omit କଲା what he has stated that ଆମେ ତିନି ଜଣ ଯାକ ଯାଉଥିଲୁ then again in the jungle he has stated that ସିଏ ତାକୁ ନେଇକିନି ଗଲା he along with deceased Sukuta went inside the forest half an hour thereafter he returned alone so and so when I asked Sima regarding Sukuta he confessed before me that he killed the deceased by means of he asked Sima as to why he killed, said that Sukuta had that accused Sima threatened me to assure. Why he killed, said Sukuta, accused Sima threatened me to kill. I expressed my mind that I would disclose the occurrence to the parents of this one. So Sima rushed towards me to assault, thereafter Swan. Now, I did not disclose this one, so Sima had threatened me to kill. Subsequently, the villagers caught hold of the accused and assaulted him and asked me this again. Asked him. Here, you tired part ta niju jo bandha aitla nije confession seta ko omit kor. Last scene omit kala jo daki kin aniba. Eta nije confessional ta ko omit kala. Next, that accused wants to assaulted. Sima told that Sukanta fell down in the high and had died. And I disclosed before the villagers that it is the accused killed Swanson.
What is this 161? 164 has been recorded.
Lordship.
PW9.
Yes.
Is it there?
So I
It
don't
has
have
not
it.
been brought to the record, I think. 164 artisan record really prayer IU.
In the paper book, it is not there.
That
It
is
has not been recorded, no. 161?
ये जो paragraph तारा cross examination रे paragraph 2 रे कहूची I do not know who called Sukuta from his house to proceed to Bapungi
Bapangia.
jungle. This PW2 says that it is this person
Yes.
himself. I was called by the accused Sima from my house to go to Bapungi jungle. Shukanta also called me along with Sima. I was also brought to the police station by police on suspicion. Was detained in the PS for 5 days and was interrogated by police. In the PS, I was also assaulted by the police, and police instructed me to speak the truth. Only a slap was given to me by the police station. I was directed to speak the truth. 5 days after the offense, I was taken to the police station. First of all, I disclosed the offense to my villagers on the day the police took PS. I also the police station on the day I was assaulted by my villagers. This is again not a correct statement. I was never assaulted by the villagers. ये जो statement है दोची, that indicates the statement indicates that he was tied and assaulted. Thereafter, this statement was made. My villagers are tied. He said only Sam Behra was tied against a pole and assaulted him.
Sima.
Sima. Sorry. Villagers have tied Sima and assaulted him at about so and so in the night, but at that time police were not present. Police arrived in the village at 10 p.m. This took place is not examined by the police in place, but police examined the station. Sima returned said general so in that parents said so that's me. So after situated distance of so and so it's not a fact that so the person who, according to your witness, was last seen had called the deceased from his house, he is now coming forward to say that this appellant also accompanied them and he sat in that place and then took the deceased and came back and told that committed murder and the subsequent conduct, he himself confessed and he was assaulted, tied. He omitted most of the thing. How do you rely on such a person how this extrajudicial confession, which as such it is held that it's a weak piece of evidence and there must be sufficient corroboration, and it is only coming from the evidence of only one witness now, because the other witnesses whatever they have stated, ame sei part taku jodi omit kariba, ମାନେ ଯୋଉଟା ଗାଁରେ ଯୋଉ ବାନ୍ଧିକିନି ବାଡେଇକିନି ହେଇଥିଲେ because the 24 ର language କୁ ନେଇକିନି, ଆଉ ଏଇଟାକୁ ଯଦି accept କରିବା ଯେ voluntarily କହିଛି ବୋଲି, let us say, but it is stated by such a witness whose conduct himself is doubtful, because how far he can be said
A truthful
witness. କାରଣ P02 case ରେ लासिन को ओमिट करदेले बाकी आरी एक्स्ट्रा जुडिशियल कन्फेशन रहउची, आउ से जो लीडिंग टू डिस्कवरी PW12 दी इन्वेस्टिगेटिंग ऑफिसर, कारण आउ इनक्वेस्ट जो माने कहते से मान तो टोटली ओमिट कर साइलेनी, जे माने कहू भी नाहंती प्रेजेंस थिला बोली, এবং इनक्वेस्ट रिपोर्ट रे मध्ये अक्यूज्ड प्रेजेंस रे इनक्वेस्ट हिच बोली भी किछि नाही, खाली लेखाइछि कन्फेशनल पार्ट लेखाइछि। तेणु एही सर्कमस्टांस रे Jahardas case where the death sentence was imposed, that same thing, that dead body of a minor girl who was raped and murdered, that was the appellant confessed and led to recovery of the dead body. That was accepted by both the courts. This court accepted, trial court also accepted. Honorable Supreme Court said, looking at that inquest report, that there is nothing about the presence of the accused, or at his instance, this dead body was detected, and only so it has been stage managed one. That word has been used, that it has been stage managed one just to create a circumstance. So, ଆପଣଙ୍କର ଯଦି ସାକ୍ଷୀ ଇଏ କରିଗଲେ, ବାକି ଏଇ ଦିଟା piece of evidence ରହିଲା, ଗୋଟେ witness ହଉଛି ଯାହାର conduct ହଉଛି ଏଇଆ, ଆର ଗୋଟେ ହଉଛି IO, how we can keep in mind those principle of Panchashil, that Sharad Bichan Sada, how this court can come to the conclusion that the chain is so complete.
Lordship, there are omissions and discrepancies on the part of PW9. I'll admit that, Your Lordship. But my humble submission is they do not lead to any contradiction to the substance of what he is submitting, my Lordship. Because the substantive part is that he was present with the deceased and the accused.
No, you are just submitting that he is a witness to the extrajudicial confession.
Yes.
Right?
Yes.
And it is a voluntary in nature, you have to say.
Yes.
But we are, as has been also pointed out, that how we'll place reliance on such a person whose conduct is this, who is ଯାହା ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଆସୁଛି, ସେ ବହୁତ ଜିନିଷ ଓମିଟ କରି କରି ଚାଲିଛି, ନିଜକୁ ସେଫ୍ ସାଇଡରେ ରଖୁଛି। ଆପଣଙ୍କର ୱିଟନେସ୍ ଗୋଟେ କହୁଛି, ଏଇ ୱିଟନେସ୍ ଆସିଲା ଡାକିକିନି ନେଲା, ସେ ପାର୍ଟକୁ କନିଙ୍ଗଲି ଆଭଏଡ କରୁଛି, ହେଲା। ଦେନ୍ ଏଇ ୱିଟନେସ୍ ବନ୍ଧା ହେଇଥିଲା, ଏଇ ୱିଟନେସ୍ କନଫେସନ କଲା, ସେ ପାର୍ଟକୁ ସେ ଓମିଟ କରୁଛି।
That is not the case of prosecution also. So with this background, whether the witness is truthful, otherwise had he been a witness in common, yes, he would have been a very important witness. But with this background, that he is one of the person who retracted himself or exculpated himself from most of the situations where it is expected that his presence was there to implicate him in the case, he has avoided. And with this background, whether this statement is sufficient to inspire confidence. And above all, you also go to section 27 of the Evidence Act. Whether the investigating agency have searched for the dead body of the deceased, it is not in a place, of course, it was thrown in a ditch, but it is not the case of the investigating agency that despite a search, they did not find the dead body in the jungle, because it is a fact that everybody has stated about the persons who have been, they have gone to the Bapangi jungle. No search has been taken. And the dead body was not in such a place that it could not have been otherwise detected had the statement not come from the mouth of the witness. So whether in fact this is a 27 evidence,
It might have been lying in an open place.
might have been so that is not the case of the investigating agency, that we searched for the dead body, we did not find it until it was disclosed by this, or what was the circumstance in the manner in which the dead body was thrown, so that it could have not been noticed by any of the persons.
It was thrown inside a ditch.
But it's not inside a ditch. You can't say what is the circumstances of the ditch, what extent, what is the depth of the ditch. There could be a ditch, we can take it. In a jungle, we can see, but that circumstance must have been described, that without the knowledge, disclosure of the accused, that it could not have been otherwise detected. That is another aspect, whether this 27 has been recorded for the sake of this case, or
just to create a circumstance against the.
Very surprisingly, he is saying that the 27 Evidence Act has been recorded in presence of PW7. And PW7 is saying that I have not seen the dead body. How could it be? He is an official witness. If you also leave the independent witnesses, we can believe the IO, provided the official witness would have supported him. See the evidence of PW7, Sudarshan Naik. He is saying, I had not seen the dead body of the deceased Santosh Swine inside Vapangi jungle, and I did not go to the place. So how could it be? That means the 27 Evidence Act, which would have been believed as has been brought through IO, we could have believed it. Not because some of the independent witnesses have retracted from their statement, we will not believe the evidence of IO. We could have. But one of the official witness who has been taken to confidence, and he is also saying that no such. See his evidence.
No, he has implicated both the.
He has implicated both the persons again.
It's not corroborated.
So a completely an extraneous thing, which is not the case of the prosecution. So once you, it has to go in one manner. Taking evidence from this page, that page, not corroborating each other or independent of that, the witnesses, if one of the witness would have been consistent to his version, that is why I wanted to see 161 of PW9. He could have stated something more also. See.
Inquest report pade apanakara jota ku inquest report jodi hela a instance jaikini ye kala tahale obviously आरो signature भी था inquest report रे आरो signature ही miss करछि जोटा को semane हाथ करथिले that was also ये जहरदास केस टा केबे report हेई एटा आसिला टिके बाबा no कोन आके देखो login करो
AIR 1991, Your Lordship.
That is the Supreme Court decision.
Yes, 1991 AIR 1388. Jawaharlal Das versus State.
Yes.
1991 AIR 1388. SCR is also there, Your Lordship.
Yes.
1991 SCR 298.
This is SCC. SCR is
Supreme Court citation. 1991 SCC 327, Your Lordship. 1991 SCC 327, 3, Volume 3, page 27.
Other 1991
SCC Volume 3, page 27.
27.
My lord.
This is not good.
Now get this side again. সেই পার্টটা দেখুন it was final and previous after something. So this is on showing of this accused. The accused pointed out the place where the dead was lying with study. This person did as far as the just see this analysis of the Honorable Supreme Court. As far as the recovery of the body is concerned, PW1 deposed that he managed to catch hold of the accused, brought him to the village, and the police came in a jeep and took the accused into custody. Then all of them went towards the paddy field, which had been pointed out by the accused, and on search they found the dead body. PW11 is the investigating officer deposed that he went to the village, found the accused to have been detained. He therefore prepared the FIR and sent the same for registration of the crime. Then he arrested the accused and his evidence thereafter put in the words which read as follows. The accused pointed out the place where the dead body of the deceased was lying, thereafter led me to the paddy field wherefrom I could recover the dead body of the deceased Disco. As there were good number of persons present apprehending danger to the accused, I sent him to the police station. During course of investigation, I examined so seized so the dead body of the deceased was lying in the paddy field where there were paddy plants which had been damaged and scattered. I held inquest over the dead body of the deceased Disco in presence of the witnesses under the inquest report Exhibit 1, noticed injuries so. Then, according to this evidence, the accused is alleged to have taken PW11 and others to the open paddy field where the dead body was lying. It is only thereafter the inquest report was done. However, PW1 stated in his evidence that before going to the paddy field, the FIR was drawn up by him. Surprisingly, we find a mention about the discovery of the body in the FIR itself, but the same is not found in the inquest. There is not even a reference to the accused in column number 9 of the inquest report, where the information of the accused as to the cause of death has to be noticed. We are aware that for the purpose of inquest report is only to ascertain the cause of death. But in a case of this nature, there should have been at least a mention in the inquest as to how the dead body was discovered. Apart from that, usually a panchanama is prepared for such discovery made under Section 27 of the Evidence Act. But strangely, in this case, there is no such panchanama, nor there is any evidence that apart from the evidence of so and so, PW6 does not say anything on this aspect. As a matter of fact, it is in the ଅନ୍ୟମାନେ ଯୋଉଟା witness ହଉଛନ୍ତି inquest report ରେ ସେମାନେ total କହିନଥିଲେ ଯେ accused instance ରେ IOR evidence ଥିଲା. So, say IOR evidence Kufuni quote କରିଛନ୍ତି. Investigating officer PW1 has stated something more that about the finding of the dead body speaks that the accused pointed out the place where the dead body of the deceased was lying and thereafter led him to the paddy field where from the dead body of the deceased could be recovered. Though this part of his evidence has not been supported by PW1, but from the evidence of 1 and 11 coupled is so, I am persuaded to hold that on the showing of the accused, the dead body of the deceased was recovered. This was the observation of the High Court. We have perused the evidence of PW4. His evidence does not in any manner incriminate the accused. PW4 deposed that the dead body of the deceased was found lying in the paddy field and that the police held inquest like the PW11 ଯେମିତି
similar.
ଆମର କହିଲା ମାନେ paddy field ରେ ଥିଲା ସେଠି ditch ରେ ଥିଲା ସେ inquest କରାଗଲା not stated about that at the instance of he does not even refer to the presence of the accused at the place where the dead body was found ଯେମିତି ଆମର PW11 ର case ହେଇଛି ସେଇ ଟାଇପ ର PW4 ର evidence ସେଇଠି ଥିଲା ଯେ ନା ତ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟରେ କିଛି ସେ କହୁଛନ୍ତି ଯେ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟର ପର୍ପସ ହଉଛି ସେୟା କଲମ ନମ୍ବର 9 ରେ ମେନସନ ହବା କଥା ଏଇ ଜିନିଷ କିନ୍ତୁ ଏଇ ଯୋଉ ସର୍କମଷ୍ଟାନ୍ସ ରେ ଡେଡ ବଡିଟା ଇଏ କଲା ତା ଦେହରେ ଆଟଲିଷ୍ଟ ସମ୍ ରେଫରେନ୍ସ ଉଡ୍ ହାଭ୍ ବିନ୍ ଦେୟାର ଏଠି ନାହିଁ ଆକ୍ୟୁଜ୍ଡ ର ସିଗ୍ନେଚର ବି ତ ନାହିଁ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟରେ ଆଣ୍ଡ ଏଇଟା ହଉଛି ଯେ PW4 ମାନେ ସେ କେସରେ ଏ କେସ ରହୁଛି PW11 ଯୋଉମାନେ କି ସାଥିରେ ଯାଇଥିଲେ and we are present they are completely silent about the presence of the appellant at the spot where the inquest was held or the dead body was recovered. ସେଇଥିପାଇଁ doubt honorable court କହିଲେ ଯେ ଏଇଟା ଯୋଉ at the instance of the accused ଏଇଟା recovery ହେଇଛି that becomes the doubtful. The conclusion is there. ତେଣୁ
No, this ratio is squarely applicable.
ହଁ ସେ ଏଠି ଆପଣଙ୍କର ଇନକ୍ୱେଷ୍ଟ ଦିଟା ସାକ୍ଷୀ ନା ଗୋଟେ ହଉଛି ଯୋଉ
PW9 PW8
ଏ 8 ହଁ 8 ଆଉ 11 ଆଉ କଣ?
11.
ଏ 8 ତ ଟୋଟାଲି ଇଏ କଲା 11 ଯୋଉ
ଟିକେ description ଦେଇଛି
11 ଟିକେ ଡେସ୍କ୍ରିପସନ ଦେଇଛି ବଟ୍ ହୋଲ ଜିନିଷ ହଉଛି ମେନ୍ ଇମ୍ପୋର୍ଟାଣ୍ଟ ହଉଛି ପ୍ରେଜେନ୍ସ ଅଫ ଦି ଯୋଉଟା କି ମାନେ PW9 ଇଜ ଦି ଓନଲି ୱିଟନେସ୍ IO এই circumstance how far
Even leaving aside the discovery part, I would only like to conclude by revisiting the evidence of PW9. Because the substance of the version of PW9 has to be given weightage, in my opinion, Your Lordship. Because even though there are omissions and discrepancies.
PW9 version which only extrajudicial confession
and last scene, Your Lordship. He has also stated that they
Yes,
both left.
that way if you
towards
say
the
it's also
forest.
last in because
Yes.
he was one amongst the persons.
Yes, Your Lordship.
But it has an intrinsic doubt. The evidence itself has an intrinsic doubt in it.
completely ଗୋଟେ witness ଉପରେ reliable ଯୋଉ ଗୋଟେ solitary witness
Yes.
ଏ point ରେ solitary witness ଯୋଉ principle ଟା ରହୁଛି cause and
He must
plea,
be of
the
sterling
trustworthy,
quality, no?
ସେଇ ଯୋଉ quality ର evidence ଏଇ ସାକ୍ଷୀ ଯିଏ କି ଏତେ ଜିନିଷ ନୁଚଉଛି ମାନେ ଆପଣଙ୍କର ଅନ୍ୟ ସାକ୍ଷୀ ଅନୁଯାୟୀ ଇଏ ନୁଚଉଛି ନିଜେ ବନ୍ଧା ହବା ନିଜେ ପିଟା ଖାଇବା ନିଜେ କନଫେସନ ନିଜେ ତାକୁ ଡାକିକିନି ଆଣିବା ଏଗୁଡାକ ସବୁ ନୁଚଉଛି ତ ଏଇ ସାକ୍ଷୀକୁ ଆପଣଙ୍କର ସାକ୍ଷୀ ଅନ୍ୟ ସାକ୍ଷୀକୁ ରଖିକିନି ଆମେ କେମିତି କହିବା ଯେ ତାର ଏଭିଡେନ୍ସ ଟା ଗୋଟେ ଷ୍ଟର୍ଲିଂ କ୍ୱାଲିଟିର ହଉଛି ଯାହା ଉପରେ ପୁଣି ଏକ୍ସଟ୍ରା
We
ଜୁଡିସିଆଲ
need no
କନଫେସନ
correlation.
ହଁ
Beyond that, we need no correlation, and it is beyond reproach. That has to be. Would you like to have anything on this statement, which is having so many? It's a checkered statement. PW9.
Yes, he's hiding certain facts that
Exactly, and those are very vital.
very vital but
Those are very vital.
ଲାଷ୍ଟ ସିନ୍ କୁ ଆଭଏଡ କଲା ମାନେ ଏଠି କଣ ଆମେ ଗ୍ରୁପ ହେଇଗଲୁ ଡାକିକିନି ଆଣିଲା ସେଇଟାକୁ ଆଭଏଡ କଲା
He has in his mind that by divulging this fact in his evidence, he might be one of the culprit. That is how he was very maintained a check and balance, exculpating himself completely, throwing some light on the incident.
one reason for that could also be because he was threatened by the accused.
no threatened ଆପଣ ଯଦି ଘଟଣାଟାକୁ ଦେଖିବେ just come to that that occurrence took place on 8 to 2003 ହେଲା so ଚୁପଚାପ ରହିଗଲା ବର୍ତ୍ତମାନ ସିଏ ମାନେ 5 ଦିନ ପର୍ଯ୍ୟନ୍ତ ଇଏ ନାହିଁ ତାପରେ ସେ ଯୋଉ ताकू जो सेठी गाँ रे सब ये ହେଇଛି तापरे then it was reported अच्छा once the matter is reported there is and the appellant is taken into custody तापर तो at least किछि fear रहिलानी तो appellant तो गोटे hardened there is some decision also मते धमकी देला एमती कहले मु डरी गली मु का कहले माने who is that person whether he is such a person जे खाली कहि देले समस्त डरी जिवे ता किछि कह गोटे पूरा विलेजर्स आपनकर पाखेर अछंती हला आपण एते कथा जानिचंती से कहि देला का कहबुने आपण चुप हे रहि जिवे ता घरे जणैबेनी काकू जणैबेनी तापरे आपण निजे कन्फेस करिवे लोकन पर हम मु मार देइछि बेली माने मु आ ए जो अपेलेंट आमे दी जण मारिछु जा आपनकर साखी कहउछन तेणु a type of what we are pointing out that how can you say that this witness is such a witness and that we can place reliance in a case under section 302 and sentence a person to life imprisonment.
Apparently, we believe this witness, suppose. And once you start separating the grant from the chaff, nothing is left in his evidence.
Anything
Mr. Mishra?
No, I've concluded my arguments.
SCRL number 68 of 2008. The appellant Seema alias Simanchal Behra with Kailas Behra faced trial in the court of Learned Additional Session Judge Bhanjanagar in Sessions case number 30 of 2003 bracket SC number 259/2003 GDC for offences punishable under section 302/34 201 of the Indian Penal Code and the co-accused Kailas Behra was also charged under section 302/109 of the Indian Penal Code. On the accusation that they committed the murder of Santosh Kumar Swai alias Sukuta, hereafter the deceased, on 8th February 2003 at about 8 a.m. and threw the dead body of the deceased to a ditch with the intention of screening themselves from legal punishment.
No C report is there, no?
The C report is there, Your Lordship, but
No.
none of the seizure of the nothing from the accused has been seized.
Okay.
Only the victim clothes and the knife, which are matching with the blood report. Only to that extent it is.
And that the co-accused Kailas Behra abated the commission of offense of murder by the appellant Seema alias Simanchal Behra. The Learned Trial Court by judgment, impugned judgment and order dated 28/6/2008, though acquitted the co-accused Kailas Behra of all the charges, but found the appellant Seema alias Simanchal Behra guilty under section 302/201 of the Indian Penal Code and sentenced him to undergo imprisonment for life and to pay fine of rupees 1,000 in default of payment of fine to undergo RI for a period of 1 year under Section 302 of the Indian Penal Code, and to undergo RI for 3 years and to pay a fine of rupees 500 in default of payment of fine to undergo RI for 6 months under Section 201 of the Indian Penal Code. The first information report was lodged by the father of the deceased, namely Choria Swine bracketary PW1, before the inspector in charge of Bhanjanagar police station on 13/2/2003, and accordingly Bhanjanagar PS case number 25 dated 13/2/2003 was registered under section 302(109) by 34 of the Indian Penal Code against the appellant, so also the co-accused Kailas Behra. As per the first information report, the deceased the informant was PW1 was informed by his wife, bracketed PW2, that the deceased was called by PW9 Pettu alias Sukru Behera on 8/2/2003 at about 8 a.m. and he didn't return home till 9/2/2003, and when PW9 was asked about the deceased by PW2, PW9 told her that the deceased had been to Hathigoda since the deceased did not return home till 13/2/2003. PW1 informed the matter before the villagers, and the villagers called the appellant, so also PW9, and confronted them about the whereabouts of the deceased. And they told that they had taken the deceased inside a jungle where the appellant stabbed the deceased with a knife and killed him. And the dead body was lying there and they have thrown the dead body inside the jungle. Hearing the such statement made by the appellants, who also PW9, the it is further mentioned in the FIR that the appellant further told that the co-accused had given a sum of rupees 1,000 to him to kill the deceased. And one Lata Dal Behra had seen them accompanying the deceased. After registration of the first information report by the IIC of Bhanjanagar Police Station, PW12, I registered the case in absence. No, after registration of the case by PW12, the SI of Police of Bhanjanagar Police Station in the absence of the IIC, he himself took up investigation of the case, recorded the statement of the informant and other witnesses, apprehended the accused persons, and it is stated that the appellant confessed his guilt before the IO and gave recovery, and his statement was recorded under section 27 of the Evidence Act, and at his instance the dead body of the deceased was recovered from a nola in the forest, and the weapon of offense, that is knife, was found in the belly of the deceased. PW12 prepared the spot map exhibit 8, conducted inquest over the dead body and prepared inquest report exhibit 5, sent the dead body for postmortem examination, and seized one bicycle as per seizure list exhibit 6/1, and he also seized the sample and bloodstain earth from the spot. The wearing apparels of the deceased were seized after the constable produced the same after postmortem examination as per seizure list exhibit 3. The appellant was then forwarded to court. PW12 then received the postmortem report. He left the seized cycle in the Jima and made a prayer to the learned SDGM. Oh, SDGM. SDGM Bhanjanagar for sending the exhibits to RFSL for chemical examination and receive the C report by exhibit 13 and he submitted the charge sheet or who submitted the kind?
Seems to be one of them.
Charge sheet ଦେଇଛି ମନୋରଞ୍ଜନ କାହା
means different.
PW12. And on completion of investigation, PW12 submitted charge sheet on 13/5/2003 against the appellants, who also the co-accused Kailas Behra under section 302, 201, 109 by 34 of the Indian Penal Code. The case was committed to the Court of Session after complying the procedure where the learned trial court framed the charges as aforesaid, but and the accused persons pleaded not guilty and claimed to be tried. The defense plea of the appellant is one of denial. In order to prove its case, the prosecution examined 12 witnesses, give it name them detail, and prosecution also exhibited 13 documents, give it 4 material objects were also give it. The Lenin trial court, after assessing the oral as well as documentary evidence on record, came to hold that from the inquest report exhibit 5 and postmortem examination report exhibit 2, it appears that there were multiple stab injuries on the deceased and knife was embedded in the abdomen of the deceased, and therefore the prosecution has proved that the deceased met the homicidal death. The Lenin trial court accepted the evidence of PW1, PW2, and PW9. And came to hold that in view of the evidence relating to the last scene, so also the recovery of the dead body at the instance of the appellant, on the basis of a statement under section 27 of the Evidence Act, and particularly the extrajudicial confession made by before PW9, it was held that These circumstances, coupled with the medical evidence, clearly indicate that the appellant to be the author of the crime. The London trial court didn't find any cogent material against the co-accused, Kailas Behera, and accordingly acquitted him of all the charges. This is item number कितने? This year. Mr. Gopal Krishna Naik, Land Counsel, appearing for the appellant, contended that it is a case based on circumstantial evidence, and so far as the Larson of the Larson theory is concerned, the evidence of PW2 indicates that the deceased was not Larson with the appellant, rather the deceased was Larson with PW9, who had called the deceased from his house, and therefore the London trial court should not have held that the deceased was Larson in the company of the appellant. It is further argued that though PW9 has stated about the extrajudicial confession made by the appellant before him relating to committing the murder of the deceased, but he has deliberately omitted some vital parts of the prosecution case from his evidence, and at one point of time he was a suspect, and he also confessed his guilt before the villagers, and the manner in which he has stated about the extrajudicial confession, it cannot be said that is a witness whose version is completely reliable and truthful, so that implicit reliance can be placed on his testimony. The London Council further argued that even though it is the prosecution case that before the villagers the appellant made the extrajudicial confession, but it appears that not only the appellant was tried but assaulted, and the number of persons were present at that time, and therefore the circumstance is such that it cannot be said that the confession was voluntary one, and therefore no reliance can be placed on such evidence adduced by the prosecution. The Land Council further argued that even though the investigating officer PW12 stated that as per the statement of the appellant, basing which was recorded under Section 27 of the Evidence Act, the dead body of the deceased was discovered from inside the jungle on being pointed by the appellant. But since he has stated that PW8 and PW11 were also present at the relevant point of time, who are also the witnesses to the inquest, their version is completely silent about the presence of the appellant when the dead body was recovered and inquest was held. And in the inquest report, there is nothing to show that about the presence of the appellant. In the column number 9 of the inquest report. And therefore, it creates doubt as to whether the dead body was recovered at the instance of the appellant. Moreover, there is nothing on record that the place was such that without the even in spite of the search of by the police and the villagers, the dead body could not have been noticed, and it was secretly hidden at one place which could be detected only at the instance of the appellant. The Land Council argued that since the evidence adduced by the prosecution is not clinching, trustworthy, and there are missing links in the chain of evidence, and it cannot be said that it has been successfully established that it is the appellant who is the author of the crime, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Sonak Misra and Additional Standing Counsel, on the other hand, supported the impugned judgment, and he argued that even though PW1 and PW2 have stated that it is the PW9 called the deceased from his house, but the evidence of PW9 is very clear that he, along with the appellant and the deceased, had gone inside the forest, where leaving him alone, the appellant and the deceased went inside and after some time, the appellant returned and confessed his guilt that he had killed the deceased by means of a knife, and he also threatened the PW9 not to disclose the matter before anyone. The Land Council argued that the postmortem report finding also indicates that the injuries were caused by sharp cutting weapon, and there were stab blows. Number of stab blows noticed by PW3, and the cause of death was also due to intraperitoneal hemorrhage due to stab injury on the abdomen and liver, and therefore the extrajudicial confession as was made by the appellant before PW9 gets corroboration from the medical evidence. The learned counsel further argued that even though the other two witnesses to the inquest are silent regarding the presence of the appellant where the dead body was recovered and inquest was conducted, but the investigating officer has stated not only about the recording of the statement under section 27 of the Evidence Act, but also leading made by the appellant to the police party to the place inside the forest where the dead body was recovered. And nothing is there in the cross-examination to disbelieve this part of evidence. And therefore, the London trial court has rightly placed reliance on such evidence to arrive at a conclusion that it is the appellant who has committed the murder of the deceased and also caused disappearance of evidence by concealing the dead body inside the jungle. And therefore, the jail criminal appeal should be dismissed. Adverting to the contention raised by the learned counsel for the respective parties, there is no dispute that there is no direct evidence in the case, then the case is based on circumstantial evidence. The principle laid down in appreciating a case based on circumstantial evidence has been so and so enumerated. So far as the circumstance relating to larceny is concerned, admittedly in the first information report, it is stated that that PW9 though in the first information report it is mentioned that the appellant so also PW9 called the deceased from his house, but PW2, the mother of the deceased, has stated that PW9 alone came to her house and called the deceased, and the deceased told her that he was proceeding to Bapangi along with PW9. And she further told that on that day, the deceased accompanied PW9 and did not return back till night. She further stated that on that day when her husband, bracketed PW1, returned, she also told him that deceased had been to Papangi along with PW9 and had not returned. PW1 has stated that PW2 was there in the house along with the deceased, and when he returned to his house at about 7 p.m., PW2 told before him that the deceased was called by PW9 and accompanied with him to Bapangi, and that the deceased did not return home. The PW1 further stated that he proceeded to the house of PW9 in order to ascertain regarding the whereabouts of the deceased, but PW9 told him that the deceased had gone to Hattigoda. Therefore, from the evidence of PW1 and PW2, it is apparent that it was PW9 who had called the deceased from his house, and that the deceased accompanied PW9 to Bapangi. And so far as the evidence of PW9 is concerned, though he has stated that on the date of occurrence, he, along with the deceased and the appellant, proceeded to Bapangi village in 2 cycles, and he Bapangi jungle, village no Bapangi jungle, but in 2 cycles, and he was a pillion rider in the cycle of the appellant, and they started from their village at about 7 a.m. and reached the jungle at about 9 a.m. But he has deliberately omitted the part of the evidence which PW1 and 2 have stated, that it was he who called the deceased from his house on that day in the morning hour. Therefore, so far as the last scene is concerned, from the evidence of PW1 and 2, it creates doubt that the appellant was last seen in the company of the deceased. Rather, it appears that it was PW9 who was last seen in the company of the deceased. Coming to the next, coming to the evidence relating to the extrajudicial confession, though PW1 has stated that the villagers brought the accused persons and tied both the accused persons, and one Ramesh Boi gave 3 to 4 slaps to the appellant and asked him regarding the deceased, and the appellant told that he had murdered the deceased along with PW9 and co-accused Kailas by stabbing on the chest of the deceased and by cutting his throat and by stabbing on his belly, and they threw the dead body inside a ditch which is situated inside a jungle. But PW2 has stated that the villagers brought the appellant and PW9 and they tied both of them in front of her house and assaulted them. And at first, the appellant told that he, along with PW9, killed the deceased, and subsequently, PW9 also told that he, along with the appellant, killed the deceased. And both of them also told that they took the deceased to Bapangi and killed by side of a river and threw the dead body there. Therefore, in the evidence of PW2, though it is mentioned that not only the two accused persons but PW9 were brought by the villagers, tried, and thereafter the confessional statement was made. In the evidence of PW2, there is no mention about the co-accused Kailas being brought by the villagers, tried, and that he made any confessional statement. The circumstances under which the confessional statement stated to have been made cannot be said to be voluntary in nature. PW1 in the cross-examination has stated that appellant had never made any extrajudicial confession before him that he, along with the other accused Kailas, committed murder of the deceased. Similarly, it has been confronted to PW2 and proved to the investigating officer bracketary PW12 that he had not stated before police that the villagers, after tying the accused persons in a pole, assaulted them, and that during the assault, the appellant disclosed before the villagers to have killed the deceased with the help of PW9. And she has also not stated that the appellant and PW9 had killed the deceased and threw the dead body by the side of the river. Therefore, in view of the contradictory statements of PW1 and PW2, the material omission in the statement of PW2, coupled with the fact that the surrounding circumstances under which the said confessional statement is stated to have been made before the villagers, it cannot be said that it was made voluntarily, and therefore we are not inclined to place any reliance on such confessional statement. Now, coming to the evidence of PW9 about the extrajudicial confession, no doubt he has stated that while he, along with the appellant and the deceased, had gone inside the jungle, Bapangi jungle, in cycles. The appellant told him to guard the cycles, and then the appellant along went inside the forest, and after half an hour, the appellant returned alone. Appellant killed the deceased by means of a knife, and when he asked the appellant as to why he killed the deceased, the appellant threatened him to kill, and also rushed towards him to assault when he expressed his mind that he would disclose the occurrence to the parents of the deceased. This witness cannot be said to be a truthful witness in as much as he has deliberately omitted that it was he who called the deceased from his house, which has been deposed to by PW2, and he has also omitted that the villagers tied him in a pole and assaulted him, and he made extrajudicial confession before them. In the cross-examination, he has rather stated that he did not know who called the deceased from his house to proceed to Bapangi jungle. And he was brought to the police station on suspicion and detained in the police station for 5 days and was interrogated by police. And in the police station, he was assaulted by the police. One slap was given to him, and he was directed to speak the truth. Law is well settled that extrajudicial confession is a weak piece of evidence, and the evidence relating to extrajudicial confession must satisfy the mind of the court that it was not only voluntarily but comes from a person on whom the accused can repose confidence, and that is a truthful witness. The manner in which the PW9 has concealed most part of the prosecution case in which the accusations are leveled against him shows that his statement is somewhat it cannot be said to be a truthful witness on whom reliance can be placed. Therefore, we are not ready to accept the submission made by the Land and Council for the state that the evidence of PW9, so far as the extrajudicial confession part is concerned, is to be accepted. The subpara. The next piece of evidence is the leading to discovery of the dead body at the instance of the appellant. PW 12 has stated that he recorded the statement of the appellant under section 27 of the Evidence Act, and the appellant admitted his guilt and led the police party and the witnesses and saw the dead body lying in a nala in the forest, where the weapon of offense was found to be embedded in the belly of the deceased. And thereafter, he prepared the inquest report, Exhibit 5. PW 12 has stated that PW 8 and PW 11 were present with the police party at the time when the appellant saw the dead body of the deceased.
7, 11.
The witnesses I have cited. PW 8, on the other hand, has stated that during course of investigation, police conducted inquest over the dead body of the deceased in his presence, and he signed the inquest report. His evidence is completely silent that at the instance of the appellant, the dead body was discovered inside the jungle, or that the appellant was at all present when the inquest was made. Similarly, PW 11 has stated that on being called by the police, he accompanied them to Bapangi jungle, where the dead body of the deceased was found, and there was puncture wound on the belly in a ditch area, and after detection of the dead body, police prepared the inquest report and he signed the inquest report. His evidence is also completely silent that at the instance of the appellant, the dead body was recovered from a ditch inside the forest, and that the appellant was present at the time of inquest. In the inquest report, neither the signature of the appellant is there, nor there is anything in it to show that about the appellant's presence at the time of preparation of the inquest, much less that the dead body was recovered at his instance. In the case of Jawaharlal Das versus State of Orissa, reported in 1991-3, Supreme Court cases, page 27. Apart from other circumstances, one circumstance was there against the accused, that the recovery of the dead body of the deceased was on showing of the accused, and that the accused pointed out the place where the dead body of the deceased was lying inside a paddy field. The Honorable Supreme Court discussed this evidence, the evidence on record, and came to hold as follows. ମୁଁ ଯୋଉଟା କହିବି ସେଟା quote କରିଦେବି ପୁରାଟା entire. Therefore, when the evidence of the other two independent witnesses are completely silent, that at the instance of the appellant, the dead body was recovered from inside the jungle in a dish, and the inquest report is completely silent in that respect. Even the signature of the appellant is also not there. It is very difficult to place reliance on the evidence of the investigating officer bracket PW12 in the peculiar facts and circumstance of the case to come to a conclusion that the prosecution has successfully proved that it is at the instance of the appellant, the dead body of the deceased was recovered from inside the jungle. The evidence on record further indicates that after the confession statement was made in the village, ସେ ଯୋଉ କହୁଛନ୍ତି ଆମେ ଯାଇ ଜଙ୍ଗଲରେ ଯୋଉ ଦେଖିଥିଲୁ ବୋଲି ନା କଣ ସେ ଯୋଉ ଲୋକଗୁଡା କିଏ ସବୁ some witnesses have stated that they went to the jungle and searched for the dead body, and there is no such evidence on record that the dead body was lying hidden in such a place that even though after knowing that it could be only detected at the instance of the accused, the appellant. The evidence of PW7, the where the home guard indicates that both the appellants were arrested by the police, and both of them disclosed to have killed the deceased and threw the dead body inside the forest of Bapangi jungle. And thereafter, the IO proceeded towards the Bapangi jungle along with the accused persons. This is contrary to the evidence of PW12, the IO, in as much as he has stated that it is only the appellant who, while in police custody, led the police party to the place where the dead body was found. PW7 PW7
he gives a complete goodbye.
PW7 in the cross-examination has stated that he had not seen the dead body of the deceased inside the jungle, Bapangi jungle, as he had not gone to the place where the dead body was lying. And thus he has given a goodbye to the evidence of PW12. And therefore, the statement of PW7 also creates doubt about the prosecution case relating to leading to discovery of the dead body at the instance of the appellant. In view of the foregoing discussions, we are of the humble view that the prosecution has neither established the last sin theory nor the extrajudicial confession made by the appellant, nor the leading to discovery of the dead body at the instance of the appellant satisfactorily. There are missing links in the chain of evidence, and we are of the view that in the present scenario, it cannot be said that the evidence relating to the circumstantial evidence forms a chain so complete that there is no escape from the conclusion that the appellant and none else who has committed the crime. And it would be very risky to, in such circumstances, it would be very risky to offer the impugned judgment and order of conviction. Accordingly, the conviction of the appellant under section 302 and 201 of the Indian Penal Code is hereby set aside. The jail criminal appeal is allowed. A bail katha konala? Acha. The appellant is on bail, so his bail bond stands cancelled. Huh? So,
I may be pardoned to make a mention. This is a criminal appeal for conviction under PC Act, and the sentence was passed without hearing. In fact, I had earlier made a mention. Your lordship directed me and passed order that I must surrender first, then appeal will be had. I have already surrendered. 80 years old. Can I be taken up tomorrow for admission?
Well, item 57. The petitioner is under custody about 9 years, out of 10 years conviction. More so his father is also maybe taken.
all right, we'll see that. They can't file.
I 146. Yeah, I have filed a IA. IA not come. IA for bail. IA number 2765.
All right, yes.
Item 41. Permitted to withdraw.
41 is CRLA number 283 of 2017.
My lord.
You are for the
Appellant, my lord. Petitioner.
appellant.
My lord.
You are filing a memo.
My lord.
All right. Disposed of as withdrawn. Yes.
Pardon to mention, my lord, we fill list item 121. As I mentioned yesterday, my lord, out of 10 years is inside custody, 9 years and 9 months.
All right, he just bring those files.
Item number.
Well, item 121, my lord. Co-accused released on bail by the
Okay.
Item 139, my lord, interim bail. I had filed an application for element of mother of the appellant, my lord. 139, my lord. Your lordship already directed to obtain the instruction.
देखिए instruction আসছে না 130.
Item 164 lordships. Last time we got call for the report for the take instruction lordships. Element of the wife of the petitioner by lot. 164 lordships.
Later they
In
can.
this case, my lord, direction was made on 13 November. I have queried today morning, my lord. Next week as well.
Okay. So Rahila will ask you next week.
Item 53, my
Hmm.
already surrender the certificate of my lord, the certificate copy of the surrender certificate.
53 Lakundu, Land Council for the
And he was out of 10 years.
appellant
More than 7 years.
files the surrender certificate of the appellant, which is taken on record. That's all.
File IN.
You have filed?
I filed.
What is that IN number?
IN number my lord 28055 of 2002.
2855
Yes, sir.
of 2023. That is for bail. All right. Land and Council for the appellant further submits that he has filed an interim application for bail by IN number 2855 of 2023. You have served the copy on the State Council.
No.
Let a copy of the interim application be served on the Land and Council for the State. Registry shall place the interim application for orders. Yes.
Pardon to mention, my lord, one CRL 786. It was earlier in the weekly list, but wrongly skipped out.
June.
May I pardon to mention, my lord, CRL number 67 of 2022. In this case, your honor, your lordship directed to approve this unlawful after examination of the victim, my lord. In the meantime, the victim has already been over. For which this case may
You have brought the certified copy of deposition of the victim.
no, my lord.
Then how can the State Council know? How can the court know that what statement has been made after? The purpose is that suppose he tells something else than what he has stated. So for that, first obtain that certified copy and then make a mention.
Oblige.
189.
Yes. 189.
Item number 180, my lord.
Please have patience. One minute. Land and Council is mentioning. This is a criminal appeal against conviction.
My lord, 10 years conviction.
Okay, dekh le. Stamp reporting person. Okay, 2 days. Yes, Mr. Tripathi, there is 2 day delay.
And item 180.
कौन पड़े व्यस्त अछंती कि अन्य कोर्टर काम सारी आसुनांती IN number 2098 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 2 days in filing this criminal appeal. After considering the submission made by the Land Council for the respective parties, since this is a case of conviction in which 10 years substantive sentence has been imposed, I am inclined to condone the delay in filing the criminal appeal. Accordingly, delay is condoned, IA is disposed of. I'd admit call for the trial court record. The interim application for bail and stay realization of fine to be considered after receipt of the trial court record. Deposition copy shall be supplied by the Land and Council for the appellant to the Land and Council for the state. Yes. Yes.
Item 180, my lord. Out of 10 years conviction, my lord, under section 376(1) IPC, and I am praying for bail. He remains in custody for near about.
Custody certificate was called for, or you have got the copy of that custody certificate?
Not written, my lord.
No, you can ask the superintendent, he will supply what is there. Otherwise, all right, take down. Item number 180. IN number 155 of 2023. This is an application for bail. Ms. Tripathi, Land Council, appearing for the appellant, submitted that out of 10 years of conviction,
out of 10 years,
10 years of sentence, the appellant has already undergone sentence of
near about 5 years, 6 months.
More than undergone half of the sentence.
Yes.
Half of the sentence. Let the Land and Council for the state produce the custody certificate from the concerned jail superintendent. Who jail achi tam koi lekhi diyon. Put up this matter on such and such date. Yes.
I told 128. 10-year conviction, 8 years already custody.
Documentary proof achi apon pakhare apon 8 years rohichandi bele. Custody certificate achi. File demo gili. Yes.
My lord, item 127, my lords.
Yeah.
Out of 10 years, my lord, he is in custody since 8 years, 11 months.
Achi custody certificate achi na mageivi.
Your lordship has called for, my lord. That is at flag. That is at in the court's file, my lord.
Well, we'll see that when the matter is. देखो उनसे file आएंगे. Yes.
No, item 198, my lord. Let's call for the custody certificate, my lord. Call for custody certificate, lordship.
Which item?
198, my lord. The 76 to lordship. 7 years, 5 months.
Just a minute. 198 that is JCRLA 55 of 23.
My lord.
So what is the sentence imposed?
10 years, lordship.
And how many years you have remained in custody?
7 years, 5 months, lordship.
All right, take down. You produce the custody certificate, Mr. Right. IN number 154 of 2023. There is an application for bail. Learning counsel for the appellant submitted that out of 10 years of sentence imposed by the Learning Trial Court, the petitioner has already undergone sentence of 7 years and 7 months. Learning counsel for the state shall obtain the custody certificate of the appellant from the concerned jail superintendent. Ko jail re achan koy
7 years, 5 months, my lord. 7.
5 months. 7 years, 5 months. Yes.
I will be pardoned, my lord. Item 67.
Yes.
There is a sentence of 10 years with the custody 6 years, 3 months.
Achi document achi apon pare.
The document.
Magei jante. IN number 1203 of 2023. This is an application for bail. The learning counsel for the appellant submits that out of 10 years of sentence imposed by the trial court, the appellant has already undergone kete rahichandi
6 ବର୍ଷ 3 ମାସ
6 years 3 months. Same. Give the name of the jail where he is there. So same order custody certificate. Yes.
Supplementary list item number 1.
Yesterday it was hard Miller, and instruction was sought for DNA report. And posted to 30/11 ଆଜି କାହିଁକି ଆଇଲା କେଜାଣି 30/11 କୁ ରହୁଛି ବା ଲେଖିଛି ଅର୍ଡର ସିଟରେ କାଲି ଥିଲା ରହିଲା 30 ତାରିଖ ପଡିନି ଦେଖିକି ଅର୍ଡର ସିଟ ଲେଖା ହେଇଛି
Item 9.
May I please vote?
Yes.
And out of 10 years of conviction for offence under section 20B2C, the petitioner is in custody for more than 4 years, 8 months, Your Lordship.
Oda heini, move out is out. They
Sir,
put
may I
up this
pray for an
matter in the
interim
month
payment
of
of 55
January 2024. Yes, next.
Item 10.
May I please, Your Lordship? The convicted offence under section 20B2C of NDPS Act, my lord. Sentence imposed to equals imprisonment, my lord, 10 years to pay fine 1 lakhs, my lord. And custody on dated 10/1/2015, my lord. During trial, the release on bail 21/5/2022. Remaining the 7 years.
10/1/2015 ने custody गले.
Yes, my lord.
Bail ले गले केवे?
21/5/2022.
21/5/2022.
During trial, man.
तब up to judgment हवा पर्यंतो you were on bail.
Yes.
Okay. After pronouncement of the judgment, you were taken into custody.
Yes, my lord.
तो कितने वर्ष होला?
7 years, 7 months, my lord.
हिसाब ठीक करचन तो?
6 months above.
एक फाइनल फॉर्म टा डिवार कले. Your name is S.K.SAHOO.
Yes, madam.
11/1/2015. It's right. This is not 10/1, 11/1. Okay. आपण custody certificate आणिଛନ୍ତି की? Mr.
No,
नहीं आसुन. And counsel for the petitioner, appellant submit that the appellant was taken into judicial custody on 11/1/2015. And during trial, he was released on bail on 21/5/2022. And again taken into judicial custody on the pronouncement of the judgment, and as such he has remained in custody for about 7 years and 7 months. Let the land and counsel for the state obtain the custody certificate. Put up this matter. Give a date. Yes, next.
Both.
Item 11. May I please, Your Lordship?
କାଲି ଯୋଉଟା ବାହାର କରିଥିଲ ଯୋଉଟା ସେଟା ରଖିଲ ହେଲା। Your associate is remaining present na, during because Mr. Mishra is now advancing his argument under Form 2B. Yes, all those issues were. Yes. Issue would have been consolidated, but issue would have been
My lord, yesterday I referred to 12 issues. If your lordship
that relates to that Form 2B.
Form 2B. I think your lordship has taken down those 12
Yes, yes, yes.
in order to substantiate and establish the allegations made by the election petitioner under paragraph 7A of his election petition, coupled together with the above 12 issues, the election petitioner has exhibited both documentary evidences as well as oral evidences. So far as documentary evidences are concerned, the petitioner has exhibited Exhibit 1, downloaded copy of nomination paper number 5 LA 2019, dated 2/4/2019, with affidavit in Form 26 dated 3/4/2019. Downloaded on 28/6/2022 at 5:11 p.m.
That is that Form 2B.
Yes, Form 2B.
Yes.
If your lordship recollects, the election petition was filed in the year 2019, 6 of 19. 3/7/2019.
Yeah.
That date also I have given and your lordship has taken note of. Then Exhibit 2 is with reference to downloading of nomination paper number 2. Exhibit 3 से सही 28/6/2022 सब गुड़ाक कर डाउनलोड. Exhibit 4 that relates to nomination number 4, downloaded on 28/6/2022. Exhibit 32, downloaded copy of candidate details. Along with the nomination paper number 2. Exhibit 32/5, nomination paper number 2 in Form 2B, downloaded on 16/11/2022. A date by material, note karto. Exhibit 33, downloaded copy of candidate details, nomination number 3, Form 2B, affidavit in Form 26, along with certificate under Section 65B. Exhibit 33/5, nomination paper number 3 in Form 2B, downloaded on 16/11/22. Exhibit 34, downloaded copy of candidate details along with the nomination paper number 4. Exhibit 34/5, then exhibit 35 say 16/11 download करछन्ति. Then exhibit 35 and with certificate under Section 65B Indian Evidence Act. Exhibit 35/5 shows nomination paper number 5 dated 2/4/2019 in Form 2B, downloaded on 16/11/2022. Then exhibit 39, 40, 41 and 42. These are original nomination papers called for by this honorable court and marked as exhibit. That relates to nomination paper number 2, 3, 4 and 5 of the respondent in Form 2B. Exhibit 39/5, downloaded printed copy of nomination paper, Exhibit 39. Exhibit 40/4, downloaded and printed copy of nomination paper, Exhibit 40, downloaded and printed in court on 3/5/23. ये पांचटा भी सब चारटा जाको 39/5, 40/4, 41/4, 42/4. ये चारटा जाको 3 तारीख रे कोर्ट रे डाउनलोड है 3/5/2023 रे. Now in all, 20 documents have been marked as exhibit by the election petitioner. What I beg to submit, your lordship may kindly look to any one of them. They have not exhibited the whole document. They have exhibited from part 1 to part 4. सेटा ठीक है देखी दिया
39
of Form 2B.
39
Can it 39, 40, 41, 42 जो गोटा को भी आप लोग देखिए देखिए.
पूरा डॉक्यूमेंट मार्क तो हिची पार्ट 4 पर्यंत
आज्ञा That is not the entire document. 5.6 is there. Part 5 is most important. Because under Part 5, the returning officer records his decision either rejecting or accepting the nomination. Here, if your lordship recollects, they are challenging the decision of the returning officer. That it has been illegally and improperly accepted. My submission to your lordship, it was incumbent upon the election petitioner to exhibit Part 5.
Okay.
Since they have not exhibited Part 5, that is the decision of the returning officer, they have substantially failed to prove their allegations made in the election petition. এটা ଟିକେ কাইন্ডলি নোট করতে হবে আপনার দরকার হলে কামটা আছে এটি গোটায় পাঠ সরু না ইয়ার পরে সেটা
Yes.
My second submission with respect to this aspect is the respondent has exhibited these documents. The decision of the returning officer. That is available to your lordship as exhibit AW1.
That is in exhibit 39.
39.
Yes.
Nomination serial 2.
Right.
Exhibit BR. Nomination serial 3. Exhibit CG. Nomination serial number 4. Exhibit CX. Nomination serial number 5.
Wherein it is mentioned that the nomination paper is in accordance with section 36 of the RPR.
And we got it marked through PW3, the returning officer,
PW3.
in course of his cross-examination.
RPR টা সিআর করে নিয়ে রাখো
if your lordship looks to the nomination paper,
Best I'm going through that 36 just.
my lord.
Okay, 36.6 says about his endorsement to be made in each nomination paper
My lord.
relating to his decision in accepting or rejecting.
Rejecting it.
Yes.
And nomination paper touch my lord 200 paper number page. Nomination paper is 200 paper number page part 5 and 6 5.
Okay. Now that has been accepted to be a valid nomination paper. That is, yes.
And 38.3 of the handbook of returning officer has been marked as 38/3. সেটা থেকে mark করবেন। Form 2B. Now we are on Form 2B.
Right.
Yes.
Yes.
Submission to your lordship is that the election petitioner has signally failed to substantiate his allegations with respect to Form 2B. Further, I beg to invite your lordship's kind attention to the pleadings of election petitioner at page 8.
About the illegal acceptance.
Illegal
of the nomination paper.
Illegal and improper acceptance of
illegal or improper acceptance. So the document on which they are relying, that shows the decision of that authority, but that part they have not
omitted.
It is you who has proved it. Which shows that it was in accordance with section 36 of the RP Act.
Rather, the downloading shows that it has been done in 22 and 23. Whereas the election petition was filed as late as in the year 2019. Submission to your lordship is they have to satisfy your lordship's judicial conscience on what document they lodged their allegations.
So obviously this downloaded copy were not with them.
Not with them.
And
it is proved that it was not with them.
99 July, if they have filed, they have not, they have simply taken the averments, but they have not stated from which source they came to know that this nomination paper was not in accordance with law, it was accepted illegally. So, okay, yes.
That is my first limb of submission in this aspect. My second limb of submission in this aspect is inviting your lordship's kind attention to page 8 and 9 of the election petition. 7B. Your lordship got it? Page 8?
Just a minute.
Bottom.
Page 9%. 8 na 9 কোটা করে
8 ର bottom 26 ଯୋଉଠି ଲେଖା ହେଇଛି paragraph 26. The nomination paper and the affidavit filed the respondent available in public platform web portal. That is HTTP. I am not reading, they have quoted it. It is pertinent to state that the respondent has submitted 4 sets of nominations papers with affidavit as per the information available in the aforesaid web portal. The petitioner downloaded the nomination papers. This is important, my lord. And the affidavit filed by the respondent from the aforesaid web portal, and came to know that the affidavit along with his nomination papers filed on 2/4/2019 is of dated 3/4/2019, which is the date subsequent to the filing of nomination
So
papers.
that downloaded copy which was made prior to the filing of election petition, that has not been brought on record.
That has not been brought. That is my second limb of submission.
Yes.
Once again, I beg to sum up my submissions with respect to the above aspect. It is humbly submitted that on behalf of the sole respondent, that while challenging the decision of the returning officer PW3 for accepting the 4 sets of nomination papers filed by the sole respondent Muhammad Mukim, the election petitioner is duty bound to exhibit the said decision of the returning officer PW3 recorded in Part 5, the respective nomination papers, the election petitioner having been failed to do so in his allegation with respect to the acceptance of nomination papers of the respondent by returning officer PW3, has not been able to substantiate and establish that the election petitioner has failed to discharge his burden of proof. I think your lordship has noted all these aspects. If your lordship make a reference to your lordship's own decision order dated 8/11/2023, your lordship has also indicated that the burden of proof lies with the petition. So that kindly देखिए.
8/10 pra?
8/11.
अच्छा 8/11/2023. Yes.
जो दिन आपण हमको स्टार्ट करिया कहले सेट. Miller, this is all about their documentary evidence. Submission to your lordship is, apart from these documentary evidences, the election petitioner has neither referred to nor exhibited any other document apart from these documents which your lordship has taken note of. Now, my lord, coming to the oral evidence, to establish his case, apart from the documentary evidence, the election petitioner has put in 2 witnesses. In total, though 3.
Three almost supported you.
Yes. Yes, that I will place, my lord. One is election petitioner himself.
And that computer, that
certificate, 65B certificate PW2 and PW3
that RO
returning officer. I will first place before your lordship the evidence of PW3 arrow. His evidence is of much importance because he is the authority, statutory authority to receive nomination from the respective parties and form 26, to receive any objection with respect thereto, give any decision whether the nomination paper or the form 26 is in accordance with law or is deficient in any way from the requirements of law, and either to accept or reject it.
And also to give an opportunity to the
Other side.
My lord. And not only that, to also to the candidate himself to rectify. That's
My lord.
some.
That I will come. Your lordship has pointed out a very important aspect.
Yes.
First, I will marshal on that opportunity. Admittedly, the respondent filed his nomination on 2019 at 11:20 a.m. Together with the affidavit in form 23, 26, dated 2/4/2019. These two documents are most material documents. These two documents are most material documents. If your lordship recollects that on 2/4/2019, while receiving these documents, Form 2B along with Form 26, affidavit, the returning officer has given a checklist.
Right.
In the checklist, he indicated that, should I can take it? He indicated that, I will place that document.
These are the documents required.
These are,
that means the affidavit is also.
so far as affidavit in Form 26 is concerned. Exhibit.
No, you continue. I just.
My lord.
The entire thing is there.
That also we will indicate in our note.
Right.
When he indicated it in his checklist with respect to Form 26, affidavit in Form 26, that these are the deficiencies in your affidavit in Form 26, and you file a fresh affidavit completed in all respects. Yes. Your lordship may kindly note the exhibit, exhibit 39/2.
The checklist.
Checklist dated
With respect to exhibit
39.
हाँ ठीक है कोटी हले से एका बोला तो
Then my lord, 40/2
हाँ
সেটা exhibit 40 পাই তারপরে 41/2 then my lord 42/2 fourth checklist
ନା ତା ଦେହରେ କେତେଟା ଡକ୍ୟୁମେଣ୍ଟ ଲେଖା ହେଇଥିଲା
କେବଳ form 26 ର କଲମ fill up ହେଇନି
ସେତିକି ଲେଖା ହେଇଥିଲା
ସେତିକି
ଆଚ୍ଛା ଦେଖ ଟିକେ ବାହାର କରେ
ସେଟା ଟିକେ ଦେଖି
39/2 ଟା ବାହାର କରେ हाँ Okay, 39/2 re affidavit in form 26 not as per prescribed format, columns number so and so not properly mentioned. Okay, not number 2 ta halla. Acha, whether the affidavit is shown before notary gala 34 so and so electoral load not applicable form A and B.
Party
Sir,
ticket.
Acha.
In order to enable him to file the nomination in part 1.
Caste certificate not applicable, security deposit, yes, so and so. So only one, that is
Only one defect
that
was shown.
about that affidavit that was not in the
following documents which have not been filed should be filed as indicated below. Item B
above mentioned columns of affidavit in form 26 have been left blank. You must submit a revised affidavit
My lord.
with the columns duly filled up before the commencement of the scrutiny once.
My lord.
So that is the only.
My lord.
Yes.
Now, my request to your lordship to pause here for a moment.
Yes.
Suppose in these 4 checklists, he has also he would have been also dealt with the deficiency in form 2B as is indicated or alleged by the election petitioner that part 2 deleted. Part 3 re igudaka nahi, not in prescribed form. Part 3A has not been answered or not in filled up. Then the returning officer should have or would have given a direction with respect to form 2B also. And if that direction would have been given, there was still 2 days more. 2 ତାରିଖରେ ମୁଁ nomination ଦେଲି, ସେଇଦିନ ଚେକଲିଷ୍ଟରେ ଯଦି ସେ ମତେ ଜଣେଇଥାନ୍ତେ ଫର୍ମ 2B ରେ ସେ ଫର୍ମ 26 ବିଷୟରେ ଜଣେଇଲେ ଯେ ଏଇଗୁଡାକ ଡେଫିସିଏନ୍ସି ଅଛି, ତୁମେ ଡ୍ୟୁଲି ଫିଲ୍ଡ ଅପ୍ ଫର୍ମ 26 ଫାଇଲ କର। ସେ ଯଦି କହିଥାନ୍ତେ ତୁମ ଫର୍ମ 2B ଟା ନଟ୍ ଇନ୍ ପ୍ରେସ୍କ୍ରାଇବ୍ଡ ଫର୍ମ କି ଏୟା ତମର ଡେଫିସିଏନ୍ସି ଅଛି, you filed a fresh 2B form.
No, Mr. Mishra, I just want to know that is there any scope in this checklist to mention anything about form 2B?
Miller?
Form 2B विषय checklist रे mention करियो किछि scope अछि कि only deals with form 26?
Yes, it deals only with form 26.
So there is no scope here, at least in this form.
Yes.
जोड़ाको सबु लेखा है सब गुड़ाको form 26 को confine करछि, apart from that the card certificate. So form 2B ପାଇଁ କିଛି ଗୋଟେ separate checklist ନାହିଁ.
Form, your lordship is absolutely correct. କିନ୍ତୁ ସେଇ receipt point ରେ ସେ ବି କହି ପାରିଥାନ୍ତେ
ନାଇଁ, ସେ ତ କୁହାଇନି, he has his observation that it is a valid one.
It is a valid
one.
ତେଣୁ ସେ କହି ନାହାନ୍ତି।
କହିନାହାନ୍ତି।
ନାଇଁ, ମୋର କଥା ହଉଛି alternate. ଯଦି କହିଥାନ୍ତେ
you would have given
still there was 2 days time,
you could have rectified it also. Okay. You could have filed a fresh set of nomination. All right.
If your lordship, I am trying to bring to your lordship's kind attention the nomination chapter in exhibit 38/3. जो aspect ଆପଣ ପଚାରୁଛନ୍ତି, that is the most important aspect.
38/3 ପାଇଲି, କଣ କୁହନ୍ତୁ?
ଆଜ୍ଞା,
କୋଉ ପେଜ ଟାକୁ କହି ଦଉନାହାନ୍ତି? 357
ଆଜ୍ଞା,
357 ଆଇଲା। annexure ଏଇଟା ତ ସେଇ ଜିନିଷଟା ନା?
ଆଜ୍ଞା, ନାଇଁ, ମୁଁ ଦେଖଉଛି ସେଥିରେ ଅଛି ଗୋଟେ important କଥା ଅଛି। ଏ ଯୋଉ nomination chapter 5(1),
ওই ଯୋଉ RP Act କଥା କହୁଛନ୍ତି?
ନାଇଁ, ଏଇ handbook of returning officer, page 69.
69 ସେଟା ତ ସେ ମାର୍କ କରୁନାହାନ୍ତି 38 ରେ
ଏଣ୍ଟାର
ଆଚ୍ଛା ଟିକେ ରୁହନ୍ତୁ
ଏଣ୍ଟାର ଇଏଟାକୁ କରିଛନ୍ତି 38
ହଁ 38 ରେ କେତେ କେତେ ପେଜ ସେଟା କହୁଛନ୍ତି
38/1
ହଁ 38/1 ପାଇଲି nomination yes
ଆଜ୍ଞା
got it yes
ଆଜ୍ଞା ସେଇଥିରେ ଦେଖନ୍ତୁ ଫର୍ମ ଅଫ ନମିନେସନ
form of nomination
5.5
5.5 exhibit ହେଇଛି ସେଟା
ଆଜ୍ଞା
right
ସେଟାକୁ 38/2 ସିଏ କରିଛନ୍ତି
ହଁ ଠିକ
The nomination of candidate for election to the House of People shall be made in Form 2A appended to Conduct of Election Rule 61. The relevant form for filing nomination of a candidate at an election to the State Legislative Assembly is in Form 2B. In case of general or by-election Legislative Assembly, the form to be used for nomination 2F 2G এটা আমার দরকার নাই রিটার্নিং অফিসার must ensure এইটা the returning officer must ensure that the candidates are given the revised form 2A 2B annexure 10 and 11 circulated by the commission in its letter number ଏତେ ସେ ଯେତେବେଳେ ରିସିଭ୍ କରିବେ he must ensure ଯେ ଠିକ ଫର୍ମରେ ଦେଇଛି କ୍ୟାଣ୍ଡିଡେଟ ନହେଲେ ସେ ରିସିଭ୍ କରିପାରିବେନି ନା କ୍ୟାଣ୍ଡିଡେଟ ଦେଇପାରିବ ନା ରିଟର୍ଣ୍ଣିଂ ଅଫିସର ରିସିଭ୍ କରିପାରିବେ ସେ କଥାଟା ବି ଅଛି ମୁଁ ଦେଖେଇ ଦଉଛି ଆପଣଙ୍କୁ
that is 5.7.2
ଆଜ୍ଞା
5.7.2
ଆଜ୍ଞା
page 71
ଆଜ୍ଞା
ସେଇଥିରେ ଭିତରେ ଅଛି
ଆଜ୍ଞା
that is heading is time and place of filing nomination
ଆଜ୍ଞା ଆଜ୍ଞା ଏଇଠି ମୁଁ ଖାଲି relevant portion
returning officer ମଝିରେ ଅଛି returning officer or assistant returning officer should not accept the nomination paper saying under what provision of law neither the candidate has a right to deliver nor the returning officer has a right to accept a nomination paper outside the hours in the so and so returning officer or the ARO may however point out if he so desire that he may present it so and so then
proper form ରେ ନହେଲେ ସେ ଦେଇପାରିବନି କ୍ୟାଣ୍ଡିଡେଟ କି ଇଏ ନେଇପାରିବନି ପ୍ରେସ୍କ୍ରାଇବ୍ଡ ଫର୍ମ ରେ ଦବ ଟାଇମ ରେ ଦବ ଏବଂ ଜାଗାରେ ବି ଦବ ସ୍ପେସିଫାଇଡ ପ୍ଲେସ ରେ ଦବ ଆଉ ସେଟା ହଲିଡେ ହେଇନଥିବ ସ୍ପେସିଫାଇଡ ଡେଟା କାହିଁକି ସେଇଟା ଯେ ଯୋଉ ଯଦି ସେଇଠି ଟିକେ ନେଗ୍ଲେକ୍ଟ ହେଇଯିବ ତାହେଲେ ସିଏ it will end in election petition and casual vacancy
that is 5.11 ରେ sub 4 ଅଛି Roman 4
ଆଜ୍ଞା
Roman 4 ରେ ଅଛି check whether the affidavit ସେଟା ଯୋଉ affidavit ବିଷୟରେ କହୁଛି duly filled
11.1 ଟା ଦେଖନ୍ତୁ ଟେକ୍ନିକାଲ ଷ୍ଟାଣ୍ଡ ପଏଣ୍ଟ ରେ ସେ ଆଗ ଚେକ୍ କରିବେ ଭିତରେ କଣ ଲେଖା ହେଇଛି ଦେଖିବେନି କିନ୍ତୁ ଟେକ୍ନିକାଲ ଷ୍ଟାଣ୍ଡ ପଏଣ୍ଟ
is not required to hold the formal scrutiny of known at that stage the preliminary examination is restricted to entries relating to the name so and so
technical standpoint ରେ ଦେଖିବେ ଯେ ଫର୍ମ ଟା ଠିକ
okay he should compare the entries if the returning of
section 33 4 ଟା ଦେଖିବେ ତା ପ୍ରୋଭାଇଜର ମଧ୍ୟ ତାଙ୍କୁ ପାୱାର ଦିଆଯାଇଛି
ଏଇଟା ସାର୍ ନୋଟ କଲେ ନା ଆଜ୍ଞା this may be read along with 33.4 ମୁଁ 33.4 ଟା ଟିକେ ପ୍ରେସ୍ କରୁଛି for your lordship's convenience on the presentation of a nomination paper the returning officer shall satisfy himself that the names and electoral roll numbers of the candidate and his proposer as entered in the nomination paper are the same as those entered in the electoral rolls. Provisoটা আହୁରି important. No misnomer and inaccurate description or clerical, technical or printing error in regard to the name of the candidate or his proposer or any person or in regard to any place mentioned in the electoral roll or the nomination. এটা পাইলে না? This has to be read in isolation of the other previous things. যাহা serial number of the voter, candidate, proposer. ଯଦି ସେଇଟାକୁ ଥିବେ ଦେଖିବେ ତାକୁ ହିଁ କରିବେ or inaccurate nomination ହେଇଥିଲେ ତାକୁ ବି ଦେଖିବେ. Provided that no misnomer or inaccurate description or clerical, technical or printing error in regard to the name of the candidate or his proposer or any other person or in regard to any place mentioned in the electoral roll or the nomination paper, and no clerical, technical or printing error in regard to the electoral roll numbers of any such persons in the electoral roll or the nominations. Any inaccurate description shall affect the full operation of the electoral roll or the nomination paper with respect to such person or place, or in any case the description is with regard to the name of such person or place is such as to be commonly understood, and the returning officer shall permit any such misnomer or inaccurate description, clerical, technical or printing error to be corrected, or where necessary direct that any such misnomer, inaccurate description, clerical, technical or printing error in the electoral roll or the nomination paper shall be overlooked.
Now, another thing, Mr. Mishra, please tell me, when you have omitted some paragraphs, some columns in the form to be itself, how the court will be satisfied that those were within the knowledge of the returning officer? If you would have mentioned that yes, I find that these parts are missing, these columns are missing, but these are not relevant so far as the candidate is concerned.
This has to be ascertained by the court. Document?
No, he has merely mentioned in part 5.
Document where it has been omitted? Together with the oral evidence of the returning officer.
No, you what is your stand? You say that these parts, part 1 or so and so, or part 3
are not relevant.
So I have omitted. He has said that it is validly accepted. So question is that whether those parts are relevant or not for the candidate.
It was incumbent upon the election petitioner to ask it to the returning officer, and they have asked, given this suggestion. And the returning officer has said that it is well within my competency to, if one part it is not relevant, and other part it is well within my competency to overlook the same.
No, whether that was in his mind at that point of time, whether any observation, he is now, while deposing in court, he is stating so.
My lord.
But while accepting the nomination paper, when there is nothing, that he has applied his mind to those things.
That would have been brought out by them from the witness. It is their witness. We cannot now put anything into the mouth of the PW3 which are not there on record. It is their witness. They have examined it. Have they brought out it from his mouth? Burden of proof lies on them. Se to kale nahi kichhi. ସେଠି ଆମେ କଣ କରିପାରିବୁ ନା
No, no, just
ଦିଟା କଥା one thing whether it is relevant or not, whether if it is relevant and omitted, whether it is a substantial defect or not. ଦିଟା ବାଟ ଅଛି ରିଟର୍ନିଂ ଅଫିସର ଆପଣଙ୍କ
no, when a duty is cast upon the returning officer at the time of accepting receiving, I'm saying receiving the nomination paper, to do so many things that he can reject, he can accept, he can ask the party to give these documents, that form 26. So he may also point out that these are the missing things. All these things are there.
Form 2B.
Okay. So, and he has to also, at that point of time, he can receive the objection.
Yes.
So many duty has been cast upon him.
Yes, yes.
So when generally this nomination paper is to, if all these columns would have been there, it would have been a containing a page, let us say 10 pages.
Minor.
And a candidate comes with a 5-page nomination paper.
Minor.
So obviously
Form 2B.
Form 2B. We are concentrating on that. So in Form 2B, when he is accepting, he founds that
receiving.
Accepting,
not
receiving,
accepting.
Receiving is found that 5 pages are missing. So that means when you will go through it, that why it should have been 10 page, why it is now 5 page.
Exactly.
So obviously you will definitely find that these are the columns which are not there. These are the parts.
ସେ କହିଥାନ୍ତେ ଆଉ ଯଦି ନ କହିଲେ ତାଙ୍କର ପାୱାର ଅଛି କି ତାକୁ ଓଭରଲୁକ୍ କରିବାକୁ 33(4) ଅନୁସାରେ ଆପଣ ଏକ୍ସାମିନ କରିପାରିବେ. କୋର୍ଟ କ୍ୟାନ୍ ଏକ୍ସାମିନ if it appeals to the judicial conscience of the court that
no, whether I'm asking just one question, that whether at that point of time he has to make a note that yes, these columns are missing, yes, these parts are missing, but this is not relevant, or this is not a substantial thing. So that is why I'm holding it to be a valid nomination paper.
Yes.
So in spite of that, he's making simple observation that it is a valid nomination paper. So please answer me that whether it was at all. Now he is explaining that it is not relevant.
No, law gives a presumption.
Yes.
There is a legal presumption in favor of all nomination paper that all nomination papers are valid. I have shown that part also at the time of cross-examination of the returning officer, if your lordship recollects. Scrutiny chapter re bhi achi. Both ways. Jodi improper acceptance hela, tahale bhi election set aside hobo. Jodi improper rejection hela, tahale bhi election set aside hobo.
No, another example, let us say in a counter, college counter, I'm giving an example. Form is being sold, and the students used to purchase the form
from the counter,
and the form contains 10 pages. Now the student will go through the form and will say that no, this out of these 10 pages, 4 pages are not relevant. I just tear it out.
Yes.
Okay. You will file, just fill up that 6 pages and file it with the authority.
Minor.
So who is to decide that whether those 4 pages are relevant for the candidate or not? It is obviously the authority.
Authority. Here the returning officer.
Returning officer.
Minor.
So in such a circumstance, whether all those 4 pages should have been there in that form, or the discretion lies with the candidate just to tear it and throw it.
Minor. That has to be decided by the returning officer. Here the authority is the returning officer.
Yes.
and your lordship is to cross-examine it, whether the decision of the returning officer in accepting a nomination which deletes part 2 is valid or not valid. First of nomination paper रे instruction भी अच्छी. Score out, strike off, part 1 or part 2, whichever is not necessary. I will go to that also.
No, that is the second part. Your submission is that strikeout is same as delete. And that I think your witness has also stated that your witness means tanko witness madhya seya kochi jahaku apana jo PW3 he said that it is
same thing.
Same thing.
And not only that, in common parlance also, all these statutory provisions are for use by the common people. See a candidate ho, ba oputara opponent ho. They are all common people. Strike. What is the meaning of phrase strikeout? Has to be understood in common man's language. I would like to refer the dictionary and
ଆଉ ଗୋଟେ ସେଇଟା ତ କରିଛନ୍ତି ଆଉ ଗୋଟେ ଯୋଉଟା ଆପଣ କାଲି ଦେଖଉଥିଲେ ଗୋଟେ କଲମ ରେ ଦିଟା ପାର୍ଟ ଅଛି ଯେ ଅମକ ଅମକ yes or no
yes ଯଦି କହିବ no ଟାକୁ ଆଉ କହିବ ନାହିଁ
ଯେ ଆପଣ ପୁରା ସେଇ ଯୋଉ ସେ ସେକେଣ୍ଡ ଟାକୁ ବି କାଟି ଦେଇଛନ୍ତି ଡିଲିଟ କରିଦେଇଛନ୍ତି ତେଣୁ ମାନେ
ତାଙ୍କର ଆଲିଗେସନ କିନ୍ତୁ ମୁଁ କାଟି ଦେଇଛି ନୁହଁ ସେକେଣ୍ଡ ପାର୍ଟ ଟା ତାଙ୍କର ଆଲିଗେସନ ହଉଛି ମୋଟେ ପାର୍ଟ 3 ଟା not filled up.
No, that we have verified that it was filled up, but some of the parts were missing.
Second sentence was deleted.
Second sentence was missing.
My lord, may kindly note.
Yeah.
Strike off.
Which dictionary?
Oxford dictionary.
Oxford dictionary. Just read it out.
Oxford, Chambers, Collins, सब dictionary भी अपन refer करी पारंती. There is no material difference between the meaning.
Strike off.
Strike off.
That is, you are referring to Oxford dictionary.
Oxford dictionary. Page
will be other.
Page
let's see what it said.
Strike off माने erase. बाद देवा बा लिभेई देवा. Which we say strike off or delete बाद देवा.
What is the meaning of strike off in that law lexicon?
Law lexicon. I mean, से phrase टाकू law lexicon रे किसी clear देई नहीं देखी छी.
At least strike off manager.
এটা ইয়া করছে struck off. The order striking of the suits were appropriately passed under the first clause of section 77 read with section 62. Consequently, the only remedy open to the plaintiff was to proceed by way of a fresh suits. And if those suits were maintainable, he could properly include claim all arrears of rent then accrued due.
So strike of erase jodi eka jinso hi thabo, then there is
minor.
You are that they
delete କରିବାଟା
हाँ,
appropriately can be accepted. বইটা ଦେଇଥାନ୍ତୁ ସାର୍ ଦେଖନ୍ତୁ ମୁଁ ତଳେ ଗାର ଦେଇଛି ଟିକେ ଆପଣ ଦେଖି ଦିଅନ୍ତୁ।
नहीं एटा हम देख सारे जे जोटा एटा ओडी इंग्लिश रो इंग्लिश ही ओडिया अछि गोटे
इंग्लिश टू इंग्लिश ता आपण चाहू
इंग्लिश टा हां सेटा टिके बेटर वे रे आउ बेसी ता माने
सेटी अछि इरेज
हां इरेज हां इतर भी अछि इरेज
आगे
वी हैव सीन इट
नहीं एठी जहा अछि इरेज सेठी भी सेया अछि इरेज
नो Mr. Mishra, it's like this. Suppose I'm writing this home. Perhaps they are telling that strike off means this.
Gara pokeva. Dita jaka na.
But no, he is telling like this. But according to you, if you can, if you just rob it in the robber and leave it, that is also means
dita jaka mu kahu nai
no it is also and that is also
both are correct.
Okay,
jadi mu if I understood in one way or other you cannot find fault with me. Number one, other hand, it is not relevant. Part 2 is not relevant. And third, it is not a substantial defect. All these three things has to be taken together to adjust and evaluate my deletion.
Yes.
My lord, may I kindly come to scrutiny chapter of that handbook of returning officer.
Kete page?
Exhibit 38.
98. Got it.
6.2. 6.1 is scrutiny of nomination by returning officer. 6.2 I am placing. Scrutiny a quasi-judicial duty. Scrutiny of nomination paper is an important quasi-judicial function. Returning officer therefore has to discharge this duty with complete judicial detachment and in accordance with the highest judicial standards. Returning officer must not allow any personal or political predilections to interfere with the procedure that he/she follows or the decision he/she takes in any case. Returning officer should be fair, impartial, and treat all candidates equally. Returning officer must also conduct himself/herself in such a manner that would appear to all concerned that he/she is following this high code of conduct. If a candidate or his agent is difficult or cantankerous, returning officer must be courteous and patient, but firm. Returning officer is expected to be prompt and orderly. Returning officer should not take any direction from any superior authority, including the chief electoral officer or the commission's observer. In deciding the validity or otherwise of a nomination paper, returning officer should only be guided by the provisions of law and the instructions given by the commission. Presumption of validity.
Next, 18 bottom.
19 bottom.
6.79.
Presumption of validity.
Validity. Dhari never every nomination is valid. There is a presumption that every nomination paper is valid unless the contrary is prima facie obvious.
Yes.
Bottom. Page 99.
Yes. Continue.
There is presumption that every nomination paper is valid unless the contrary is prima facie obvious or has been made out. In case of a doubt as to the validity of a nomination paper, the benefit of such doubt must go to the candidate concerned and the nomination paper should be held to be valid. Remember that whenever a candidate's nomination paper is rejected without proper reason, that can be a reason to set aside the election in an election petition. Returning officers should adopt a comparatively liberal approach in dealing with minor technical or clerical errors. Subsection 4 of Section 36 mandates that nomination paper shall not be rejected on a ground or defect which is not substantial. Then kindly come to 6.9.
Insufficient ground.
Insufficient ground.
6.9.1.
6.9.1. Do not reject any nomination paper on the ground of any defect which is not of a substantial character. 36.4 of the said Act. Any mistake or error on a technical or clerical nature should therefore be ignored by the returning officer. I will continue on your lordship's next sitting. In our next sitting, I will place your lordship the relevant oral evidence.
The form to be
Form to.
Thank you.
So we'll keep it tomorrow?
No, I had already prayed before your lordship. Tomorrow, day after, I am totally preoccupied.
Or a Tuesday then?
28
at 3 o'clock?
At 3 o'clock.